We start with the trooper and then we move on to the driver. Sir?
Yes, good morning, Magistrate Banky. It's going to be Daniel McLaughlin.
Thank you. And Ms. Rodriguez, tell me your name.
I'm Melissa Rodriguez.
Okay, this is the date and time set for your informal hearing. Hold on one second. Let me admit this third driver. Then I don't have to repeat myself. Miss Rutkowski, this is Magistrate Jill Banky. I'm in the middle of a hearing, but I'd like you to listen because what I have to say applies to you when your case is called. All of the drivers appearing before me for a informal hearing have three choices, and you have to make your selection when I call your case. You can, one, admit responsibility. That's where you admit that you did what the traffic ticket says you did. It immediately goes to me to assess fines and costs. I've been on the bench over 2 years now. No one ever picks that one, but you can pick it if you want. Number two, you admit responsibility with explanation. That means you're admitting that you did what the traffic ticket says you did. Okay, you're admitting you did it, but you give an explanation as to why. That means the explanation is for the benefit of the trooper, not for me, because only the trooper has the power and the discretion during this hearing to grant you a break. So when people are looking for a break, you're saying to the court, to the trooper, I did what the traffic ticket says I did. So we're not going to get into if you did it or not, because you're admitting that you did it. But here's why. Okay. And this was going on. And then if you're sorry, you say you're sorry. You talk about how you treated the trooper during the stop. I can tell you if you were combative, disrespectful, and or rude, it's going to be hard to get a deal today. You should also address with the trooper what you've learned from this experience and any changes, if any, you've made to your driving habits. Okay. The only way we can save on points, people are like, I just don't want the points, is if the trooper hears your explanation and is willing to give you a break. I cannot tell the Secretary of State, like, I find you responsible, but no points. The points are a deal between you and the Secretary of State. There's nothing the court or the trooper can do about that other than amending the charge or the infraction to something different, which means less points and or less fines and costs. The third choice that you have is you deny responsibility. That's where you're saying to the court and to the trooper, I didn't do what the ticket says I did. That's where you deny it. We have an informal hearing. I swear on the witnesses. I take testimony. Receive any other evidence you'd like me to receive. The trooper has the burden of proof. If he proves just by a preponderance of the evidence, that's a slight, you will leave the hearing with no ticket, or you will leave the hearing with the ticket as written. By proceeding today, you give up your right to be represented by an attorney. You give up your right to have this matter heard by a trial judge. I am only a magistrate or a jury. Okay. If you admit responsibility or admit responsibility with explanation, you do not have a right of an appeal. Your admission is binding upon you. You may file a motion. You have buyer's remorse to set aside that party admission. I review the motion, and there's no guarantee that I will allow it to set aside. So know that when you admit responsibility, you may leave this hearing with the ticket exactly as written. At the end, if you decide to deny responsibility, at the end of the hearing, if either side is dissatisfied with my ruling, you may file an appeal and have this matter heard by the trial judge. Having heard all that, Ms. Rodriguez, how would you like to proceed?
I would like to proceed with the explanation.
Okay, that's admit responsibility with explanation on the mobile device. And what would you like Trooper McLaughlin to hear about you, ma'am?
So that day, I actually picked up my grandson and from my daughter, who have actually now live with me. She was in an abusive situation. It was a really hectic day. I did have one hand on the phone and on the steering wheel. I was trying to make it to a place to buy a crib. And for some reason, my GPS that was connected to my car wasn't working that day. So I also, he mentioned trying to figure out another device. So I did buy another phone device. That is what I learned from it. This is my first ticket in a very, very long time.
Okay, so the new law is you can't have the phone. There's no GPS excuse anymore. People used to say that, then the law changed, I think last summer or the summer before.
Oh.
You can't have it touching any body part while you
Oh,
drive.
well, that's
Yeah.
good to know.
Yeah,
Thank
yeah,
you.
it can't be in your lap. You can't have your hand on it. It has to be removed. Right, Trooper? Is that?
Yep, yes,
And yeah,
so
this elaborate explanation of it being removed, is that accurate?
no, it's okay. So the exact verbiage would be to have it affixed to your dashboard or your windshield, as I explained to you roadside, Miss Rodriguez. You can't have it in your hand for any reason whatsoever. The citation basically states prohibited holding of any mobile device. So therefore, you having it in your hands, when I observed you with two-hand manipulation driving with your knees and a child in the back seat, that's what I observed not once but twice. So respectfully, with you saying that you had one hand on the steering wheel, you didn't. You had two hands on your phone with manipulation, eyes off the roadway, driving with your knees with a child in the back seat. I respect that your explanation is the way it is, but unfortunately, because you had precious cargo in the back, I am not looking to give any deals today. This needs to be a real learning lesson for you with the fact that you're traveling with someone else in the backseat of that vehicle, someone who is very defenseless. Okay, I hope that you understand that and can be
No, I do
reasonable.
understand that. That's why I got the devices and got it fixed. So if I'm not getting any deals today, I was hoping to at least not get anything sent to Secretary of State, or at least be able to have a payment plan.
Yeah, I
As an
can give you the
explanation,
payment
magistrate.
plan, but I don't, like I said, I don't give, I can't do anything. Like, I can't say don't abstract. I mean, my hands are tied. The law doesn't give me that power. But I can't find the mobile device list on here. 1 second, please. I'm sorry, what? No, it is. I don't think it's, it goes to the Secretary of State, but it's not points, right, Trooper? And then the penalties escalate as, where is my fines? The
I'm tracking what you're
penalties
saying.
escalate. I think, yeah, they escalate, but 1 second, please.
Yep. So the way that I think it is it's going to be if you get one or more offenses is when it comes into fruition for points and insurance issues and things like that. Being a first offense, which is as it was written, I don't believe it carries either.
Yeah, and I haven't had a ticket, gosh, since I was probably younger 20s. So that's why I'm like, you know, it was surprising. I did learn from it, but if I could at least just get an opportunity, because like I said, I just took my daughter and my grandson in. So any kind of lower payment would be very
Right,
helpful.
I'm looking up what the fine, I have discretion on the fines and costs.
Oh, okay.
It's not on my list and my Madam Clerk is looking it up for me, please.
Had that.
Okay, sorry, we had a miscommunication here. The normal fines and costs are 220. The court will reduce it to 185. How long do you need to pay?
A few months would be great.
I'll give you 45 days to pay.
Okay.
Okay? And you
Perfect.
can pay online. You can come to the counter. We're always happy to have you, ma'am. Or you can, what's the other one? Mail us a check or money order, okay?
Okay, perfect.
All
Thank you
right,
so
thank
much.
you. Take care and be well.
Thanks.
All right, thank you, Trooper. That was your only case.
Absolutely. Have a wonderful
Okay,
day.
you may leave the Zoom. Thank you. Are we at 9:01, 9:15? All right, calling the case number of SP 4515352. Your appearance, please, sir. That tells me tell me your name. Mr. Sorry. Can I start over, please? Calling the case of SP 4515352. This is the state of Michigan versus Jacques Edward Chouinard. Your appearance, please. Your name, sir.
Yes, my name is Jacques Edward Chenard.
Okay, the defendant has appeared. The officer has failed to appear. It is 9:18. It's Trooper McLaughlin, and the trooper has failed to appear. So this will be dismissed without prejudice. Any objection?
No objection.
Okay, thank you so much. You may leave the Zoom.
Okay.
Thank you. Take care. Calling the case of SP 4507897. This is the state of Michigan versus Joanne Rutkowski. Your appearance, please. I need you to start your video and unmute yourself.
Hello.
Good morning.
Good
Your
morning.
appearance, please. That means tell me your name, ma'am.
Oh, I'm sorry. Joanne Rutkowski.
Okay, Joanne. This is the date and time set for the informal hearing. It was set for it was set for 9. Oh, you're at 9:31. Did I see that other one? Your case is not set for 9:31, so I can't call you. I thought you were 9:01. This for sure was 9:01. I could call it. So, okay, you can hold tight because your trooper might still appear. Okay. You're way early, and I thought I misread it. I thought you were set for 9:31 and 9:01. Okay, hold tight. Thank you, ma'am.
You're welcome.
We can start with the swear.
We're going to start with the swear to. The jail will come on. Mr. Angot can listen. You'll go in the breakout room, and then he'll talk on bond. Does
Perfect.
that work for everybody?
That
Works.
All right, calling the case number 2500929. This is the state of Michigan versus Kimberly Ray Champin Newberry. Hyphenated,
That is right.
and the C name goes first.
Yes, Your Honor.
Okay, this is the state of Michigan versus Kimberly Campaign Newberry. This is two matters before the court. We'll first have the swear to, and then if the complaint and warrant are signed, then we'll conduct the arraignment. Present for the swear to is the complaining witness. Will you identify yourself, sir?
Detective Vanderhoff of the Royal Police Department.
And also MIDC counsel John Angot, your appearance, please.
John Ann appearing on behalf of the defendant.
Okay, detective, will you raise your right hand? Do you swear or affirm that the testimony you're going to give in support of the felony complaint is true?
I do, Your Honor.
Okay, the court has before it a proposed felony complaint, general information, wherein it is alleged that on or about May 28, 2025, in the city of Royal Oak, that the defendant did, contrary to law, knowingly or intentionally possess less than 25 grams of cocaine. This is being charged as a 4-year felony or $25,000, commonly known as possession of cocaine, MCL 333.7403. Count 2 on the same date did resist, obstruct, or impose a Royal Oak police officer. This is being charged as a 2-year felony and or $2,000. This is known as assaulting, resisting, or obstructing a police officer. Count 3 on the same date that the defendant, the owner of a Lincoln, a motor vehicle, drove without insurance. This is being charged as a misdemeanor, 1 year, known as operation without security. The proposed complaint is signed by the assistant prosecuting attorney and that of the complaining witness. Sir, is that your signature?
It is, Your Honor.
Okay, the court will take your testimony in support.
Good morning, Your Honor. Detective Vanderhoff.
Good morning.
For the Royal Oak Police Department. Before you today is a 3-count warrant charging Kimberly Campaign Newberry with possession of cocaine, obstructing, and no insurance. The facts of the case are documented under Royal Oak Police Report number 25-17154 and are summarized as follows. On May 28th, 2025, at approximately 23:55 hours, Officer Yax and Officer Patron observed a white Lincoln MKX bearing Michigan plate DHY 843 on northbound Woodward near Catalpa in the city of Royal Oak. Officer Yax checked the plate through Lean and SOS, which showed the vehicle had no insurance, EIV no. In addition, officers observed that the vehicle had a cracked windshield. Officers conducted a traffic stop and spoke with the driver and lone occupant of the vehicle, Kimberly. Kimberly advised that her insurance might have lapsed. Officers asked Kimberly for consent to search the vehicle, which she denied. Officers checked Kimberly through Lean SOS, which showed she had a valid license and no outstanding warrants. Officer Patron and Yax approached the driver's side of the vehicle and requested that Kimberly step out of the vehicle due to the fact that she did not have insurance and that the vehicle was going to be impounded. Kimberly refused to get out of the vehicle, and after several attempts, officers had to physically remove her from the driver's seat. As officers were placing Kimberly in the back of the police vehicle, she admitted that there was crack cocaine in the center console. In the center console, officers located Tupperware containing suspected crack cocaine, a handmade pipe, some charboy, a razor blade, and a drill bit. In addition, officers located a small clear container with suspected crack cocaine, a spoon with white residue, push rods, and 2 boxes of Suboxone with the name ripped off the label. The vehicle was impounded and Kimberly was arrested for possession of cocaine, obstructing, and no insurance. At ROPD, the suspected crack cocaine was tested with a Nick wipe, which showed a positive result by turning blue. I checked Kimberly through maps, which showed she is prescribed Suboxone, and the script was last filled on 05/09 of 2025. With that, Your Honor, 05/09 of 2025.
Okay, so the script was hers.
The script was hers.
Maybe.
It
Okay,
is,
go on.
yeah, according to maps.
Okay,
With that, Your Honor, the warrant is before you.
okay. The court has heard the testimony of the complaining witness. The court finds that probable cause exists for the issuance of the complaint and warrant that the charges are not frivolous and or capricious. As such, the court will sign the complaint and information. Okay, Mr. Angott, when the jail comes on, we'll put you in a breakout room, okay?
Thank you, Your Honor.
All right, thank you. I don't know why my video is not coming through
Oh, okay.
on Oak Video. Do you?
I can see what's going on.
Is Charles Parks, are you on the video, Charles Parks?
Yes, that's me. Yes, ma'am.
Okay, we just can't see you. Can you see us?
Okay, it says on my screen, it says if you're the host, press 5.
You're not the host, but can you hit start video?
No, there's no buttons for me to hit anywhere.
Can you see us? Can you see me and?
No, I just see a screen that says, please wait, the host will let you in soon.
That's so weird because you're admitted.
Hmm.
Okay,
you gotta
hold on, please.
Yes, ma'am.
Okay, this, Mr. Schwartz, while we're working out the technical difficulty, the case number is 22-01480.
Thank you.
And there was a bench warrant for failing to appear for a show cause hearing on May 23, 2024. This is a fines and cost case. The balance owing is $1,336.
Yeah.
Well, when I spoke with.
1 second, sir.
Oh, okay.
I'm just giving background until I
Okay,
can
no
formally
worries.
call the case.
Yeah.
Sir, Mr. Parks, before we call the case where you could see us, is the Ypsilanti Street a good address for you?
Yes, ma'am.
Okay. All All right, that will shortcut it. So give us a second, all right?
Sure.
Yes, ma'am.
I did that. Let's see.
Should I add call, hold to accept?
I'm sorry, what is your prompt?
It says add call, decline, hold and accept, hang up and accept.
Accept. Yeah, because my
whole
madam
accept?
clerk is on with administration there and
Oh,
we're
no, I
trying,
can't touch anything.
we can't touch it.
No, I'm touching it, but it's not a touch screen.
Like MC Hammer, you can't touch this.
Yes, ma'am. Yeah,
Okay, give us a second.
deputy.
I would like to see you so that this is meaningful for you, but if I do have an objection if we proceed, oh, maybe there's a new one. coming. If I'll remove one, he came through again without video.
For what it's worth, I can identify his voice if you would have to go.
I know,
forward.
I just, okay, let's see.
Sure.
Now I muted him and he can't unmute.
The wonders of modern technology.
I tell you, sometimes like Zoom is a blessing and other times I miss the in-person. You know
Yeah,
what I mean?
I
Like,
get it.
can you please unmute? I can't hear you. You're frozen. But this is not this gentleman's fault, so.
No.
They were.
Okay, they're having tech issues, so. Now I can't. We're gonna remove this.
Well, while we're waiting.
No,
just in
wait,
case-
I had to remove the other one because it was echoing.
Okay.
Mr., let me get back to his case, please. Mr. Parks, can you hear me? Oh, he can't unmute. Did he leave?
I never saw him in the first place.
No.
No,
No,
I mean,
he's not here.
even when his video wasn't going, I couldn't see it.
Oh, you couldn't see him as an attendee?
I couldn't see anything saying OCJ or anything.
Oh, yeah, it was here, but now it's gone.
Okay.
But
while we're waiting, I just want to give you a heads up because there might be something in the file to help us figure out what's going on because he claims that.
here we go, here we
Oh, there
go.
we go. Okay, now we got him.
Okay, thank you. Calling the case number of 2201480. This is the case of the City of Royal Oak versus Charles Christopher Parks. Your appearance, please.
Good morning, Your Honor. Jeffrey Schwartz, P32076.
Good morning,
am
sir.
House-
Thank you for helping today.
Okay.
Go ahead.
I am House Counsel for purposes of arraignment only. Waive the reading of the warrant and stand mute. Your Honor, I have spoken with Mr. Parks and he indicates to me that he was incarcerated for 6 months in another jurisdiction and just before release was brought in April, roughly April 20th by video to your court and indicates that this matter was resolved. So I don't know what the mix-up is, but that's what he's telling me.
Yeah, and I
Okay.
was-
One second, please. 1 second, please.
Yes, ma'am, I'm sorry.
Okay, no, that's okay. Thank you. I'm sorry for the technical difficulties, okay?
Yes.
So this is the arraignment for the bench warrant because according to the information I have, you owe $1,336 dollars to the court, okay?
Yes,
So
ma'am.
I'm just going to recall and set aside the bench warrant. When we were off the record, before I formally called your case, we were trying to work on technical difficulties. You confirmed that the Ypsilanti Street in Pontiac is a good address for you, correct, sir?
Yes, ma'am.
All right, thank you. Do you have a phone number?
No, ma'am.
Okay,
I'm homeless. That's just a mailing address for me. My sister's home.
Okay. Thank you for that. I'll note that. And the court is going to set this matter. I'm just going to set a personal bond in the amount of $1,336. Okay. And we're gonna set this matter for a show cause. Okay, sir?
Well, no, but I just got a little bit of an issue with that because, again, when I got released, I did 6 months for cocaine possession.
Okay,
And then April of 2023, I had to go in front of the judge, just like I am right now, to get released. And they said, okay, everything's taken care of. I don't have the money to pay them. I don't have the money to pay them. I'm not on any sort of payment plan with them. And I thought it was gonna go to collections, was my understanding. And then
okay, so
got
this is
released.
what it shows happened in 2023. That the bench warrant was canceled and they set it for a show cause hearing. And then you failed to appear and we keep resetting
have
hearings.
Ma'am, I don't have transportation. I live in Pontiac.
Oh,
I have no.
yeah,
way of
okay,
getting
so
out.
show cause hearings, I don't mean to speak over you, I'm sorry.
No,
Show
I-
cause hearings are by Zoom, okay?
Yeah, well, I got a thing going on. I'm waiting to get sentenced. I think I'm gonna go to the penitentiary in a month.
Okay,
So, a show cause hearing, if we can't do it within a month, it's just gonna be another, I'm just gonna keep being in this cycle. I don't know, until
Okay.
the bench is dissolved.
okay,
got-
so why don't I make a note of that for the trial judge to review it? Okay, to see if they want to set it for a different kind of hearing or some type of review.
Can we just send it to collections?
I'm not sure how that works because I don't work in that department.
Yeah, it just seems like the judges, this was a $700 ticket, and because I missed every time, they just say, oh, we gotta do another show cause, and it cost me another 250 miracle dollars that I don't even own. So then I don't go to the show cause because I have no way of getting around, and then they say, okay, you go to jail, and then they see you, and then they say, okay, we're gonna lift the warrant, but we're gonna do another show cause for another $250, and the same thing has been happening since 2018 when this case has happened.
Okay, so
So-
I'm gonna make a note of your
More
status.
show cause hearings, more money that I don't have, a
Okay.
$700 ticket.
Sir,
I'm
sir,
getting-
she's trying
sir,
to
I'm
tell
getting
you
it.
that she only has the authority to set a hearing and then hopefully you
Right.
could
Okay,
find
so
someone to help you
yes,
soon.
so I am just the magistrate.
Yes,
And
ma'am.
I do the arraignments, and so I'm going to talk to the trial judge to see if he wants to set a different kind of hearing for you to end this cycle. And I
Yeah, that-
understand your frustration because you owe us money, but you are without the funds. And then you have another issue. Right, and then we keep meeting and you would like to have some finality. Do I hear you correctly?
Yes, correctly, because if you
Okay,
gave me a
and
personal
then-
bond and I get released today, it would just happen again and I would owe another 250. It'd be 1,500 instead of 1,300.
Right,
If I was.
I
if you
mean,
just
I
gave me-
could set a cash bond, but I'm technically not supposed to
Oh, no,
because it's
personal
only a
bond is
fines and
fine.
cost case.
Yeah,
so-
no, I'm saying I'm not going anywhere regardless, but if I was to go anywhere, say I didn't have this other case looming over my head, sending me to the penitentiary. If I was getting out today on a personal bond, the same thing would happen. I would miss the show cause and it would be another 300.
I understand.
Yes,
I'm
ma'am.
going to set this aside and see if the judge wants to set it for a different kind of hearing for you or a different
Okay.
kind of review. Because the law doesn't give me the discretion to fix this for you at this hearing. Okay,
Okay.
not fix it, but address it for you. Okay,
Okay.
so I just have limited powers and I can only do this for you. So I'm
Okay.
going to set for a show cause. But I'm gonna set it aside and talk to the judge, okay?
Yes, ma'am.
I'm gonna carry
if I
it,
see
I'm gonna take the
something-
file upstairs myself.
Keep an eye on your mail so you'll know what the dates are.
Yeah, I'm going to the penitentiary. I won't have no mail.
Well,
Okay,
I thought
well-
if you got a personal bond, you're still not gonna be released. Is that what you're telling me?
Yeah.
He's waiting on
yesterday I
another
lost-
case.
Okay.
Like yesterday, I lost that trial, so they reprimanded me, even though I was out on bond for 2 years. What was another month? I don't understand. I don't understand the law. I was out for 2 years, but then I get found guilty. They won't let me get another month to get my ducks in a row to go to penitentiary.
Okay,
they
so you're
recommend-
remanded is what you're telling me.
Yes, yes,
Okay.
yes.
Well-
I am.
Okay.
So I,
Well, we
All
can
right,
go in
so-
circles, but the magistrate has other cases she has to get to, and there's
Okay.
not
Sure.
anything more she
Yeah.
can do for you.
yeah, no, that's fine. Thank you very
Okay.
much. Have a great
No,
day.
Okay.
I understand the difficulty. Thank you and good
Thank
luck
you.
to you, sir.
No, thank you.
Okay. All right, thank you. Take care. Thank you, Mr. Schwartz.
Thank
for
you.
Helping the court with this docket today. Take care.
Yeah, bye-bye.
Okay,
Have a good
bye-bye.
day.
Okay. Okay, Mr. Angott, the jail's coming back in. Were you able to speak with the defendant or? Yes?
Yes, we're all
Okay.
set, Judge. We're ready to go.
Okay, so I mean, this can start getting processed, but you know, I need to go talk to the judge. Okay, please. Okay, so we're staying now recalling case number 2500929. This is the state of Michigan versus Kimberly Campaign Newberry. We just had the swear to where the complaining witness and Mr. Angott were present. Thank you for that. And now Mr. Angott and the complaint and warrant have been signed. And now we're going to proceed with the arraignment portion of the hearing. Your appearances, please.
Thank you. Good morning, Your Honor. John Angott appearing on behalf of Miss Campion Newberry. Judge, we're both here via Zoom. We both consent to the use of Zoom for this hearing. As noted, this is an arraignment. Judge, I did relate to my client the 3 charges. Count 1 being possession of cocaine less than 25 grams, a 4-year felony. Count 2 being resisting and obstructing a police officer, which is a 2-year felony. And then count 3 being a no insurance misdemeanor, a 1-year misdemeanor. Judge, I did talk about the nature of the charges, the possible penalties as to each. We talked about her statutory right to demand a preliminary examination at the 44th District Court as to those 2 felonies. And we talked about her constitutional trial rights going forward. I believe she understands all of those rights. As such, Judge, I would ask the court to waive formal reading and stand my client mute.
Okay, and also present for the hearing, your name, sir?
Detective Vanderhoff for the Rural Police Department.
Okay, thank you. So defendant will waive the formal reading based upon your representations. Defendant stands mute. A not guilty plea shall enter and is assigned counsel requested.
Judge, Miss Campion Newberry indicated to me that she has a long-term relationship with the attorney she'd like to retain. And so despite the fact of her financial stress at this point, she believes that he will still work with her. So she's not requesting assigned counsel.
Okay, good morning, ma'am. How are you? My name is Jill Binky. How are you? You are entitled to retain your own attorney, okay? But you're also entitled to have an attorney assigned to you. So in circumstances like this, if you qualify for an assigned counsel, I sometimes suggest that counsel be assigned to you in the interim in case you can't come up with the funds or you know, the attorney's not available who you wish to retain. And then that way there's no gap in representation and you'll always be represented. So
I think I should take that.
I think you should take that too. I think that's a good choice. Any objection to that, Mr. Angott?
No, Judge, I appreciate you telling her that. Thank you.
Okay, so assigned counsel to be assigned in the interim. Or permanently if defendant doesn't retain. Okay, I see that you chatted me something while I was in another hearing. Let me check. All right, you've chatted me the Ferndale. And okay, so the address and phone we have on file is confirmed. Now let's talk about bond and bond conditions and we'll hear from Detective. Can you come closer to the Zoom? Thank you.
Good morning again, Your Honor. Detective Vanderhoff for the Royal Police Department. here to speak to bond regarding Kimberly Campine Newberry. I'd just like to make the court aware that Kimberly has an extensive criminal history, including a prior possession of narcotics out of the 17th District Court on 01/31 of 2003. With that, I would like to request the appropriate cash bond and drug testing, Your Honor.
Okay, and response on bond, Mr. Angott.
Thank you, Your Honor. Judge, I appreciate the detective noting that charge. I guess I would note that's some 22 years ago. There is a criminal history. I understand that. I talked about that with my client. My understanding, though, Judge, is she has no bench warrants outstanding at this point. I don't believe that she, at least she doesn't believe she has any kind of capious history. These are not crimes of violence. Certainly the RNO at times could be categorized as such, but I think the facts of this case don't really rise to the level of any violence. That being said, Judge, she has a local address. She's a homeowner there. She has a mortgage, but it is her home. She's been there now for a couple of years, I believe. Unfortunately, she's not working at this time. I don't disagree with drug testing. Perhaps that kind of intervention is necessary at this point. But that being said, Judge, I think this case, these charges really rise up to a personal bond with whatever terms, including testing, you deem necessary.
Okay. 1 second. I need to review the file. I'll be right back.
Cut out. Hello?
Lives in Ferndale.
Yes, she's a homeowner there.
I'm disabled.
Oh, you're disabled. Do you get disability?
Well, I did, but no, because of my husband's disability.
Okay. Are you still married?
Yes, but separated.
Okay.
He left me about 5 years ago.
Okay. The court is setting the following bond and bond conditions. You have to personally appear, whether by Zoom or in person, as ordered by the court, for any and all court events, conferences, exam, arraignment, trial, and sentencing. You shall abide by any judgment entered in this case and surrender to serve any sentence imposed. You shall not leave the state of Michigan without permission of the court. You may not commit any crime while released. Driving your car without insurance will be a crime. You shall immediately notify the court in writing of any change of address from Martin Road or the phone number ending in 3170. You are not to use alcohol, marijuana, or any other illegal controlled substance. You will be working with pretrial services. You'll be supervised by pretrial services. You shall check in 1 time per week.
Okay.
Number 2, you shall drug test 3 times per month.
Okay.
And you shall ETG alcohol test.
What is that?
That's a type of alcohol test 3 times per month as well. Okay. So you're going to be supervised, meaning you're going to have to call them and let them know where you're living, what you're doing.
Right.
I encourage you to get employment. I also encourage you to get substance abuse help. If you don't have resources, there's plenty of free ones out there. And your bond is going to be a $10,000 personal bond.
Thank you so much.
We're going to set this matter for, this is a felony, right? Set this matter for a probable cause conference. That will be set no less than 7 days, no more than 14 days. So you'll have assigned counsel if you don't have an attorney before this is set, but if you retain your own counsel, they'll do a substitution and he or she should appear for that. We'll also set this for a preliminary exam. Is there anything further requested or required of the court, detective?
Not at this time, Your Honor.
Counsel.
Judge, I believe Ms. Campion Newberry has a question. I think what you're asking, it's like a pretrial. It's where your attorney will meet with the prosecutor, okay?
Okay, by the way, you, defendant must contact pretrial services. What is Tuesday. By, that's June what? June,
That's June.
June 3rd,
Yeah, June.
June 3rd by 2 o'clock. To set up testing. And supervision, okay?
They're
And
gonna give
ma'am,
you a sheet of paper with the number on it, Miss Campion Newberry.
I'm sorry.
and
You need to
They're gonna-
contact them on Tuesday or
Oh.
before Tuesday.
Okay,
they will not have your file today, so you will not see them. They will, if you call today, they won't know who you are, but Monday takes one business day. So you have until Tuesday to set that up, okay?
all right.
All right, thank you. This concludes your arraignment.
Thank you so much, Your Honor.
Thank you,
Okay,
Your Honor.
thank you.
Yeah, okay. So I got a personal. Yeah.
The time of the stop, it'll be difficult for. But that. Okay, 10:01, 10:01. Pano, can you start your video? Alexis and not Pano, can you start your video?
Yeah.
Okay, and is the other person on the phone, are you Suman Ahmed?
Yes.
Okay, I'll rename you, please. Okay, yours is set for 10:01. Okay, Mr. Ahmed, I'd like you to listen what I say in this first case because it applies to you, okay?
Yes.
So you'll just mute yourself and when your case is called, but I want you to listen, okay?
Okay.
All right, calling the case of S 250S 10811. This is the state of Michigan versus Alexis Marcella Payano. Your appearances, please.
Hello, how are you doing, Your Honor?
Good, your name?
Alexis Magdaleno Payano.
Okay, and the deputy, your name, you should have gone first. Sorry about that. Your name?
Deputy Crystal Lemke.
Good morning. All right, this is the date and time set for the informal hearing. Ma'am, you have three choices. You have to make a choice out of three options this morning. One, you may admit responsibility where it goes to me to assess fines and costs. Two, you may admit responsibility with explanation. That's where you say, I did. With the ticket says I did, but here's my explanation. Here's what was going on. And here's how I conducted myself during the traffic stop. And this is what I've learned. Okay, if you were less than kind, respectful, or courteous to the officer at the time of the stop, it'll be difficult for the officer to grant you any grace or consideration. If you admit responsibility with explanation, there's no guarantee that the deputy will make any motion to reduce your ticket to anything other than the ticket as written. So no, if you admit responsibility or admit responsibility with explanation, you may leave the hearing with the ticket exactly as written. Okay. If you admit responsibility or admit responsibility with explanation, you do not have a right of an appeal. However, if you have buyer's remorse, you may file a motion to set aside your party admission. The motion, you will have to post a bond. The motion may or may not be granted. Or you can deny responsibility. That's where you're saying to the court, you didn't do what the ticket says you did. And then we swear in, we have an informal hearing. I swear in the witnesses, I take testimony. I hear from the deputy first, then you, And then the deputy at the end of that hearing, I either have to find you responsible or not responsible for the ticket as written. The deputy has the burden of proof to prove that you did what the ticket says you did by a preponderance of the evidence. That's only like a little tipping of the scales. That's an all or nothing proposition. You'll either leave the hearing with the ticket or no ticket. If at the end of the informal hearing, you are just, either side is dissatisfied or unhappy with my ruling, you do have a right of an appeal. By proceeding today with an informal hearing, you give up your right to be represented by an attorney, to have this matter heard by a trial judge. I'm only a magistrate and or a jury. Having said all that, ma'am, what is your choice?
Your Honor, is there a choice to see the prosecutor?
Nope, this is an informal hearing, so there's no city attorney. There's no one to negotiate on behalf of the deputy. Like that would be where you ask for an informal hearing. I'm sorry, a formal hearing with the trial judge. Then as prosecutor or city attorney would be involved.
I don't understand. Sorry.
Well, I can't really give you legal advice, but there's no prosecutor or city attorney on this Zoom. The deputy is representing the state of Michigan. So you requested an informal hearing. So at this point, you either have to say that you want a formal hearing, which I don't know if it's too late for that, or you have to make one of the choices. Can you convert to a formal hearing today? Or you can request a formal hearing right now. And then you're gonna have to come at a different day, and you may be represented by an attorney. Or you may talk to the city attorney if you represent yourself.
Yeah, I would like a formal hearing. Thank you so much. I'm so sorry. I didn't really know the rules.
That's okay. So defendant requests a formal hearing. Okay, deputy, you may leave the Zoom.
Thank you.
Thank you so much. All right, take care, both of you.
Thank you so much.
Okay.
Thank you, Your Honor.
Okay, thank you. You may leave the Zoom.
Thank you so much.
Okay, calling the case number SP 4508385. This is the state of Michigan versus Suman Ahmed. Your
Yes, ma'am.
appearance. Tell me your name.
Yeah, I'm Suman Ahmed.
Okay. This is the date and time set for your informal hearing. It was set for 10:01. It is now 10:16. Let's see if I'm there. The officer has failed to appear. So this will be dismissed without prejudice. Any objection?
Thank you, ma'am.
Okay, sir, stop driving like this. Okay, I know the officer has not today, and that resulted in this being dismissed, but you're very young to be driving in such a ridiculous way. I've read the remarks on this ticket. You caused an accident, and then instead of learning from it as a young driver, you thought that you should have this hearing today and maybe not have any consequences to your actions.
Okay,
Because
ma'am.
no,
Thank you, ma'am.
no, I'm not asking for an okay. You're a very young driver. You
Yes, I
sideswiped.
apologize.
No, you drove and then you still wanted a hearing. You don't want any consequences. You don't want any points. You better change your driving habits immediately, because
Yes, ma'am.
Next time, it's gonna be, I don't even want to say it, a serious injury or death. And it's gonna be on you. So if you
Okay.
cannot handle the responsibility of driving like a mature adult and a good citizen, do everyone a favor and stop driving. Okay?
Okay, ma'am.
Not funny. It's not funny. Stop driving.
Okay, ma'am.
If you can't handle it and you think you're so important to cut people off and cause accidents, and that however you want to drive or wherever you have to be is more important than obeying the law and not causing property damage or injury, then you know what? You're not mature enough to drive. It's a big responsibility. So you know what? Don't drive. Give up your license and figure something out in life. Because I can tell you this, if you continue to drive like this, it's going to be very bad consequences for you, either financially and legally and morally. Okay? So
Yeah.
this may be where the ticket got dismissed because the officer didn't appeal, but that's not because you're not responsible and you didn't do what this ticket says you did. And seriously consider stop driving, because you know what? I don't want to be on the road with you. I really don't. I don't want my mom on the road with you. I don't think I even want your mom on the road with you. Okay? So why don't we stop cutting people off, drive the speed limits, slow down, and keep a safe space, or hang up the keys? Are we clear?
Yes, ma'am.
Okay, thank you. May leave the Zoom.
Thank you, ma'am. Have a good day.
And good morning, everyone.
Morning.
Court does call the case of Arbor Manor versus Patrick Brooks.
Good morning, Eli Heights P 84976 for the plaintiff.
Mr. Brooks?
Good morning.
I do see him. Mr. Brooks?
Good morning.
Good morning. Okay, what is plaintiff's claim in this case?
Yes, Your Honor. Rent to retain is $2,250. Court cost of $178 for a total of $2,428.
All right, Mr. Brooks, how are you intending on getting that paid, sir?
Well, I was actually hoping to be compensated in some way because my apartment has been down and under construction since February, maybe the 26th. The plumbing is messed up. When you flush the toilet, everything goes straight to the basement floor.
What I'm going to need from you then, given that, is I'm going to need a written answer that is going to need to be filed by June 5th, 2025.
Okay.
I will reserve the issue of escrow from this date. And then I will adjourn this out to June 6th, 2025 at 1 p.m. And that is an in-person hearing. And sir, you have to make sure that when you provide the written answer to the court, you also provide a copy of the written answer to plaintiff's attorney.
Yes, sir.
All right. Okay, thank you. We'll see you then.
Thank you.
Court does call the case of Arbor Manor versus Jamaica Jones.
Good morning again, Eli Heights P 84976 for the plaintiff.
Jamaica Jones, they are not present. You have second service. If you raise your right hand to be sworn, you can take a default. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead, sir.
Yes, sir. Rent to retain, $651, court cost of $178 for a total of $829. And I request a writ date of June 9th.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. Forrest Knoll versus Tequila Smith.
This is her.
Oh, good morning again. Eli Hydes, P 84976 for the plaintiff.
You get her, she's a phone. You're right. All right. All right. What is the claim in this case?
Rent to retain, $1,249.38, court cost of $178, total of $1,427.38.
Ms. Smith, how are you intending on getting that paid?
I do have half the money, but I need something. So now that I'm going to court, they're saying they're going to move my apartment now. I've been living with mold for over a year. Water leaks. I can't take a shower at home. Every time I take a shower, it leaks down into my kitchen. They haven't did nothing in my apartment in over 2 years. Before I got new management, my apartment was neglected. Me and my kids, our health is starting to mess with our health. My son has asthma, and it's keep messing with his health. It's starting to irritate our eyes and everything. My doctor said I don't even supposed to be living in this apartment because the mold is so bad.
All right. What I will do is there are repair issues here. I will reserve the issue of escrow in this matter. You are to file a written answer with the court, provide a copy to plaintiff's counsel of what your complaints are. You're to do that by June 5th, 2025.
So do I come to the courts and do that?
Well, you can come to the court. You have to file that answer with the court.
Okay, because I have pictures. I have pictures and everything.
I understand,
So,
ma'am,
yeah.
but you're gonna need to file this answer by June 5th as to what your complaints are. All right?
Okay, thank
As
you.
to all of your repair issues and all of your other complaints that you have. As I've indicated, escrow is reserved. And I will adjourn this matter to June 6, 2025, 1 p.m. That is an in-person hearing.
Okay, and just come into what courthouse to do it?
That is the courthouse by the sheriff's department.
Okay, thank you so much.
All right, thank you.
Thanks.
Forrest Knoll versus S.E. Cleveland.
Good morning again. Eli Hydes, P 84976 for the plaintiff.
S.E. Cleveland, no response. You have second service. You've been sworn. You may proceed.
Thanks, Your Honor. Rent to retain, $740, court cost $178, total $918. Requested writ date of June 9th.
You said 9/15?
9/18, sorry.
All right. Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with a writ issue in 10 days. All right. That's it for you, sir.
Yep, you have a good weekend.
All right, you do the same. Sile Farms versus Jonathan Barrera.
Good morning, Your Honor. Sydney Fontanella, P 86316 for the plaintiff.
Hi. All right. Mr. Barrera?
Yes, sir.
Is not. Oh, that's it. You got him? Yeah. Okay. What is plaintiff's claim in this case?
Your Honor, I'm showing that there's rent due of $2,201.44, court costs of $190 for a total of $2,391.44 currently due.
All right. Mr. Barrera, how are you intending on getting that paid, sir?
Certified check, sir. I can pay that today.
Okay, you said you think you can pay it today?
Yep.
Okay. I will indicate in the file that you're going to pay the balance today. I will adjourn this out 1 week to June 6, 2025 at 1 p.m. If you don't pay it, that's an in-person hearing. So if you don't pay it, you need to appear in court. If you pay it today, just make sure that your account is at 0. You don't need to appear, and it's likely they'll dismiss the matter. Okay?
Okay.
All right. Thank you.
Thank you. And Your Honor, what time was that at again?
That was at 1 p.m.
Thank you.
All right. Sile Farms versus Caitlin Bell.
Sydney Fontanella for the plaintiff.
Ms. Bell?
Morning.
Good morning. Okay, what is plaintiff's claim?
Your Honor, I'm showing that there's rent due of $1,702.92, court costs of $190 for a total of $1,892.92.
And Ms. Bell, how were you intending on getting that paid?
Well, I was actually thinking of selling the home as I do own the home to the park, if they are willing to do that.
Okay. Ms. Fontanella, you know anything about that?
This is the first time I'm hearing anything. My manager, Patty, is on. So, Miss Bella, I would encourage you to reach out to Patty in the management office. I would expect that they'll need to do a walkthrough and determine, a price if they are interested in the home. I can't guarantee that they will be, though.
Okay, that's fine.
So what I will do is I'll adjourn this out. Hopefully we can get something accomplished. June 6, 2025, 1 p.m. Contact them right away. And Ms. Bell, that is an in-person hearing. All right?
All right.
Thank you.
Thank you.
Sile Farms versus Raphael Bell.
Sydney Fontanelle for the plaintiff, and Your Honor, I would move to dismiss this case without prejudice. The tenant has paid in full.
All right. This case is dismissed without prejudice. Court calls the case of Sile Farms versus Logan Edgar.
Sydney Fontanella for the plaintiff.
Said he's here.
Yes.
Logan Edgar, excuse me.
Present, sorry.
Okay, no, it's okay. All right, what is plaintiff's claim in this case?
Your Honor, I'm showing that there's rent due of $2,057.62, court costs of $190 for a total of $2,247.62 currently due.
Sir, how are you intending on getting that paid?
By means of a family loan, I'll have that paid within the next 10 days.
In 10 days, are you gonna be able to pay it by next week?
Probably, yeah.
Okay, well, I'm gonna adjourn it out to June 6, 2025, 1 p.m. And I would indicate, sir, that if you get it paid before then and make sure your balance is clear, it's likely that they would dismiss it. But you're clicking over it to another month, so you want to make sure your balance is clear.
Yep, very good.
Okay, thank you. That's an in-person hearing, by the way, if I didn't say so.
All right, thanks, sir.
Thank you. Sile Farms versus Robert Hayes.
Sydney Fontanella for the plaintiff.
Said he's here.
He was here. He's not there.
Robert Hayes. You said he was here?
Yeah, he absolutely was here.
And just dropped, or?
I don't know when.
Oh, pardon?
The rest of his block is hers.
It's, what I'm gonna do is, let me pass that one, see if they sign back in.
Sounds good.
Sile Farms versus Jennifer Knight.
Sydney Fontanella for the plaintiff, Your Honor.
Jennifer Knight. You have her? I do not have her. Jennifer Knight, not here. I don't believe I've sworn you in. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead.
Thank you, Your Honor. I am requesting a default judgment in light of the second mailing. There is current rent due of $2,197.04, court costs of $190 for a total of $2,387.04. And I would request writ to issue in 10 days, which I believe puts us at June 9th.
Judgment to the plaintiff, that is by default. For possession, redemption amount is in the amount requested with the writ to issue in 10 days. Sile Farms versus Elise Liu.
Sydney Fontanella for plaintiff.
Yes, I am here, Your Honor.
Okay, there's Miss Liu. All right. And what is plaintiff's claim?
Your Honor, I'm showing that there's rent due of $1,932.92, court costs of $190 for a total of $2,122.92.
All right, Miss Liu, how are you intending on getting that paid?
I get paid in 2 weeks. I can have that paid, so next Friday and then the Friday after I get paid. I could have that paid, so then 2 Fridays from now.
Okay, you lost me there. All right, so you get a check on the 6th and then also on the 13th. Is that what you're indicating?
Yes, Your Honor.
Okay, so and that's the next time that you can make a payment, correct?
Yes, Your Honor. I can make a payment on next Friday of half of and then, sorry, so 1 week from now I can pay half. The second week from now I can pay all of it.
Okay, will that include your June rent?
I believe so, Your Honor. Yes.
Okay, all right. So give me a dollar figure as to how much you think you can have next week.
$1,000.
Okay, so what I'm gonna do is I'm gonna indicate that you're gonna pay $1,000. You're gonna pay that by the 6th. If you can pay it by the 5th, that would be great, but by the 6th, that's fine, because I don't think we'll clear this balance. How much is your monthly rent?
I believe it's somewhere around $870 a month.
Okay. So we're still gonna be up around the same balance if you only pay 1,000 when June clicks in, so. Here's what I'll do. I'll adjourn this out to June 6, 2025, 1 PM. That's an in-person hearing, ma'am. Okay, so you need to get that paid or as much as you can get paid, and then we'll see where we go from there.
Thank you very much, Your Honor.
All right, thank you. Sile Farms versus Michael Moore.
Sydney Fontanella for plaintiff.
Pardon? Michael Moore. No response. You may proceed.
Thank you, Your Honor. I am requesting a default judgment. I am showing that there is rent due of $1,857.28, court costs of $190 for a total of $2,047.28, and I would request writ to issue in 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with the writ issue in 10 days. Sile Farms versus Gregory Pennington.
Sydney Fontanella for the plaintiff.
Hello, Your Honor.
Hello, Mr. Pennington. All right, what is plaintiff's claim in this case?
Your Honor, I'm showing that there's rent due of $1,611.73, court costs of $190 for a total of $1,801.73 due.
All right. And sir, how are you intending on getting that paid?
I'm going to today after work, I get out of work, I'm going to give them 800 today, and then next Friday I'm going to have the rest.
So you're going to pay 100 today?
No, 800.
800, I'm sorry. All right,
You're all right.
800 today. And then by next Friday, you intend to have the balance of that amount paid? What about
Yes.
your June rent?
Yeah, it's going to take me like a week or so because I got a little behind because I had car repairs and
Okay.
I'm trying to catch up. Like I said, I'm trying to work all the overtime I can where I try to volunteer as much as I can at work, so I can get much of it.
I got you.
Yeah.
So you think you're going to have about 800 today and then about 1,000 by next week?
Correct, Your Honor.
All right. So I'm going to mark the file that you're going to do that. But since you're not paying it before the end of the next month, this case will continue on because we got to figure out what to do with June rent. What's your monthly rent?
I do this $12.94, I do believe. That's not including my water bill or nothing.
Got it. Okay. So if you get that all paid, we're likely going to be around that same figure, but we'll figure it out where we go. But you got to make those payments. Okay.
Yeah, that's why I'm trying to get it sooner because I'm like I said, it's been a couple months I've been behind, but I'm trying to get it progress more, get closer and closer to my due date, instead of so far behind like this.
I got you.
I
Okay,
appreciate
so
it.
I'll adjourn this out to June 6, 2025, 1 PM. Sir, that is an in-person hearing. All right, so get that paid and then we'll figure out where we go from there, all right?
So if I pay it up by then and then I still gotta come in person?
Well, yes, because here's the problem. if you get everything paid by the 30th, by today, they'd certainly, I think, dismiss and almost would have to if you get everything paid. However, you're going to click over into June. And so
Right.
June rent won't be paid and they can they can claim June rent at that time.
It's just hard. It's hard for me to get off work. That's why you said in person.
All right, you can file a request. I can't guarantee to be granted for a Zoom hearing. I'll take it into consideration because we don't want you to miss work because then that causes problems with you paying your rent.
I think I appreciate that, Your Honor.
All right. All right. Just make sure you get the form and fill that out for the Zoom request. All right.
Where do I get the form from?
Go ahead. If you put your email in the chat, we'll send it to you by email.
Okay, put it where I go down in the chat part and then put my email and then you guys respond back to me.
Yes.
Thank you so
my
much.
My staff is willing to do that for you because they're nice. I'm not. So. All right.
I appreciate it, Your Honor.
All right. You take care.
You too. Thank you. Bye.
Bye-bye. Scio Farms versus Brendan. Is it Petros?
Sydney Fontanelle for the plaintiff, and Your Honor, I am requesting that this case be dismissed without prejudice. He is paid in full.
All right. This case is dismissed without prejudice. Court does call the case of Scio Farms versus, is it Jarek Turgeon?
Good morning, Your Honor.
Good morning. All right. And what is plaintiff's claim in this case?
Your Honor, I'm showing that there's rent due of $1,962.92, court costs of $190, for a total of $2,152.92 due.
And sir, how are you intending on getting that paid?
I'm currently working with Veteran Affairs. They said that they should be able to cover April through July rent and that I should be receiving a check from them next week.
Okay, who's this you're working with?
Veterans Affairs.
Okay, so you're a vet?
Yes, sir.
You're a vet, sir?
Yes, sir.
All right, what branch?
Army.
Army? Okay, I'm not gonna hold that against you. I'm a Navy kid, but that's all right. All right. Okay, so you're working with Veterans Affairs and they said they're gonna pay your back rent. Do you know if they're gonna pay anything forward on it or anything?
Yes, sir. They said they'll pay June and July as well.
Okay. So they're trying to work all of that out for you. And you think that check is gonna arrive next week?
Yes, sir. That's what I was told.
Okay. So here's what I'll do. I'll adjourn this out June 6, 2025 at 1 p.m. That's an in-person hearing. I'm sure if they get the check and June's paid, they'll dismiss the case out and everything. So you won't have to appear. But if the check, is the check coming to you or to your landlord?
They said that they'll bring it, they should be getting it to me and then I'll drop it off.
And then you'll have to pay it off. Okay, so if everything's paid, including your June rent, you don't have to appear next week. But if it's not paid, it'll be an in-person hearing and you'll need to appear.
Okay.
All right. All right. Thank you, sir.
All right. Have a good day, Your Honor.
You do the same. Scio Farms versus Melanie Wackenhut. And Michael Wackenhut. Sorry, counsel.
Sydney Fontanelle for the plaintiff, and Your Honor, I am requesting that this case be dismissed without prejudice. The tenants have paid.
Case is dismissed. That's without prejudice. Court does call the case of Scio Farms versus Derek Wanshan, excuse me, and also Elizabeth.
Sydney Fontanelle for the plaintiff.
And
okay, I am here, Elizabeth Watson.
Okay. All right. And what is plaintiff's claim?
Your Honor, I'm showing that there's rent due of $2,323.22, court costs of $230, for a total of $2,553.22.
All right. And ma'am, how are you intending on getting that paid?
My husband and we did reach out to Hawk. They're still working to help us with that. They're still in the process right now.
Okay.
My husband is working full time. And we weren't sure. We can pay $800 right now.
Okay, you can?
Yeah.
Okay. Let me ask you this so we can, I'm just working with rough math here. What's your monthly rent?
Right now it's $870, but when it gets to June, it's gonna be $915.
Okay, so 915, when I adjourn this out, 915 is gonna click onto this number, which is then gonna put me at 34. Okay, so the reason I wanted to know is if Hawk pays the maximum, they'll pay, but I don't know that they'll pay the maximum. You've got to have this balance under 3,000. So when I
Okay.
adjourn it out, if nothing is paid, you'll be over the 3,000. That's why I was asking those questions. All right.
Okay.
Okay. So you can pay 800 today.
Yes.
Okay. Why don't you get that paid? Pay 800, pay that to the landlord. I know they'll say they won't take it, but now they will. Because Patty's
Okay,
here. She'll take your money. All right.
Okay.
Okay. So pay the 800. Then I
Okay.
will adjourn this out to June 6th, 2025, 1 p.m. That's an in-person hearing, okay, ma'am? So,
Okay.
and then we'll try to figure out where you're going. Hopefully we'll have some news from Hawk also.
All righty.
Okay? All right. Thank you. You have a great weekend.
Thank you. You too.
Scio Farms versus Danielle Williams and Daniel Blethyn.
Sydney Fontanella for the plaintiff.
Either party here. Williams, Blethyn. There, Blethyn. No, that's right. Neither party is here. You may proceed.
Thank you, Your Honor. I am requesting a default judgment. There is current rent due of $2,298.91. Court costs of $230 for a total of $2,528.91. And I would request writ to issue in 10 days.
Judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested with the writ issued in 10 days. Valley Ranch versus Kimberly Irizarry, maybe how it's pronounced, and really Hassan Akutrani.
Sydney Fontanella for the plaintiff, Your Honor.
Good morning, Your Honor.
Good morning. Okay, I butchered your name. Tell me
Don't
how I
even worry
pronounce
about it. It's typical. It always happens.
it. All right. Okay. All right. What is plaintiff's claim in this case?
Your Honor, I'm showing that there's rent due of $1,859.14. Court costs of $182 for a total of $2,041.14.
2040. And I'm sorry, what was the sentence count?
14.
14. All right. And sir?
Yes, sir.
How are you guys intending on getting that paid?
So I get paid this Monday. I will be able to pay about roughly $1,400, and by the end of Friday of next week, I'll be able to pay the rest.
Okay. So you hang on. You can pay $1,400 by the 2nd, right?
Yeah. Yes, Your Honor.
Okay. And how much is your monthly rent?
$1,575.
Okay. So you're gonna go down about 100. So, and then you think you can have the 21 paid, which is roughly the balance. You can have that paid by the 6th.
Yes, Your Honor. I'll have all of it paid by then.
Okay,
And then,
but but you said it's gonna be late on that day that it's gonna be paid?
Yes, Your Honor. And also, my fiance is also getting her refund, her student refund, and so am I, because we're attending school this summer. So that will
Okay.
also help towards next month's rent too. So we will be fine on that.
Okay, well, where are you students?
At Washtenaw.
Okay, did they say when those are gonna come in?
June 6th, roughly.
Okay,
Yeah,
all
so
right.
literally
No,
on
that's
the day.
okay. Just don't hold your breath.
Yeah.
I have to deal with this every semester. It may come in, then it may not, but I get you
Yeah.
in terms of what your plans are. So what
Thank
I
you,
will
Your
do
Honor.
is I'll adjourn this to June 6, 2025 at 1 p.m. That's an in-person hearing. Get the $1,400 paid, and then we'll figure out where we're gonna go with the rest of this, all
Thank you.
right?
Thank you so much, Your Honor. I appreciate it.
All right, thank you. You do the same, sir.
Have a good day.
You
God
too.
bless.
Thank you. Scio Farm versus Robert Hayes.
Sydney Fontanelle for the plaintiff, Your Honor.
Did not come back. All right, I'll let you proceed and take it to fall.
Thank you, Your Honor. I am showing that there's rent due of $1,088.36, court costs of $190 for a total of $1,278.36, and I would request for it to issue in 10 days.
Judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested with a writ issue in 10 days. I think that's all I have for you, Sydney.
Yes, you'll see me this afternoon.
Patty, because she's becoming a fixture here. So, all right. All right. Sydney, take care of yourself. Great
I'll see
seeing
you. Yeah, I'll see you this.
John Cass versus Joshua Byers.
Yeah, good morning. Tom Pietrowski on behalf of plaintiff.
Mr. Byers.
Mr. Byers?
Hello, Your Honor. Good morning.
All right, this is first hearing. Good morning. What is plaintiff's claim in this case, including cost?
Including cost, Your Honor, of $1,438. That's 1438.
Okay. And Mr. Byers, how are you intending on getting that paid?
Currently, I am trying to look for work. Doing what I can to get this cost worked out, honestly.
Okay, between now and next week, is there anything that you could pay, sir?
I'm sure I can come up with something, but right now I'm not making too much. So I'm trying to figure out how to take care of my immediate expenses.
Yeah, I'm out of town next week. I have no objection to court putting it, if it's available, to the 13th, allowing Mr. Byers a little additional time as well.
All right. And your June rent will click in, so.
Yes, sir.
So the 13th, Mr. Pietrowski.
All right. So I'll adjourn this to June 13th, 2025, 1 p.m. That's an in-person hearing, sir.
Okay.
All right. Thank you, folks.
Thank you, Your Honor.
Thank you. Kevin, is it Osentowski versus Thomas Warren?
Good morning, Your Honor. Lori Brewis on behalf of Evan Osentowski, the plaintiff.
Thomas Warren?
Yes, I'm here.
Okay, I'll need a camera on. But while you do that, what is plaintiff's claim, including cost in this matter?
There are no costs in this matter, Your Honor. This is a forcible entry, was made after, or possession was held by force after peaceful entry. And he was requested to leave. There is no rent due in this particular matter. And at this time, Mr. Warren has moved out of the home.
Is that correct, Mr. Warren?
Actually, I've only partially moved. By the way, I tried turning on my camera. For some reason, it won't turn on. I don't know why. Anyhow, but I've only moved a few things out of the premises, and I have a temporary storage place that I'm putting items in right now. The notice for this meeting, though, I only got this like a day and a half ago.
Do you have a time period at which you'll be out?
Right now, I'm trying to get the rest of my things out of there, as soon as possible. I had rented a truck and moved a few things over the last week and a half, but I had to return the truck. They had it reserved for somebody else, so I'm in the process of reserving another one.
All right. Well, what I'm going to do is you're entitled to an adjournment. I'll adjourn this to June 6, 2025, 1 p.m. That is an in-person hearing. All right.
Oh, okay.
Thank you. Thank you.
Thank you, Your Honor.
Thank you. Ridgewood Apartments versus Amy Wisner. And
I had it as a
Ms.
non-payment.
Good morning, Your Honor. Mark Spasser appearing on behalf of plaintiff.
That's how it's in James. I'll look at it.
Amy Weisner.
all right. And what is plaintiff's claim in this case?
Just as a non-payment of rent action, currently rent to retain is $3,408. Court cost $224.50. Total would be $3,632.50. $3,632.50. This is possession and money claimed, Your Honor.
Yes, sir. All right. And ma'am, how are you intending on getting this paid?
I'm working with the MDHHS and the SER programs. I was on the phone with them yesterday and they're trying to escalate it so that I can get some support.
Okay, so you applied through DHHS. How many people are in your unit?
3, my children and I.
All right. So just so that you know, the most that they're going to pay is $620, I think. For 3 people in the unit, so you got to keep that in mind. Have you contacted Hawk at all? I'm not sure what
No,
their funding is right now.
Yeah, they gave me that information yesterday when I was on the phone with them.
Okay, so have you applied?
Nope, I'll do it today. It was about 4:45 when we wrapped up our call yesterday, so it was too late.
Okay, so you'll need to do that. Try to arrange something along those lines. Is there anything that you can pay between now and next week?
Well, I actually have an interview with in about 2 hours today, so possibly.
Okay, all right. Well, what I'll do is I'll give you a 1-week adjournment, June 6, 2025. That's at 1 p.m. That's an in-person hearing. Ma'am, there is a form in your, since you've applied for SER, there's a form in your packet. You can either do that or use the QR code or come down to the court. It's called a rental assistance form. You'll need to fill that out and have that to the court by next Wednesday.
Okay, rental assistance form by Wednesday.
Yes, ma'am.
Okay.
All right.
Okay,
Thank you. We'll see you next week.
Okay, bye.
Thanks, Judge. Have a great day.
You do the same.
Thank you.
West Ridge Mobile Home Park versus Cindy Alvarado Lopez.
Good morning. Good morning, Your Honor. Jarrett Levine for the plaintiff.
Good morning.
Good morning.
Okay. Okay, ma'am, I see you there. Well, I hear you there. You'll need to turn on your camera. Counsel, what is plaintiff's claim in this case?
Claim is for non-payment of rent. We're showing $893.98 for rent to retain, plus costs of $183 for a total present balance of $1,076.98.
All right. And ma'am,
Yes.
how are you intending on getting that paid?
I tried to pay for the end of the June.
I'm sorry?
Yes, I trying to pay for the end of the on June.
Okay, I'm not in June yet, but you say you want to pay. Are you trying to tell me you want to pay everything by the end of June?
Yes.
Okay. I don't know. You're going to have to try to work that out with the landlord. I'm not sure whether or not they'll wait that long. What I will do is I will adjourn this out June 6, 2025 at 1 p.m. That's an in-person hearing, ma'am. Is there anything that you could pay between now and next week?
Yes, I can pay, but not all the,
Okay, how much do you think you can pay?
like 600.
600?
Yes.
Okay, so I'm going to indicate you need to pay 600. You need to pay that by the 5th.
Okay.
So that we
Got
can have record of it. Okay?
Okay.
And then we'll see. What's your monthly rent?
585, I think so. But I pay the mobile home too separately.
Okay. So this might cover at least the June rent, so we don't go up any higher, but we'll see. All right, June 6, 2025, 1 p.m. All
Okay.
right?
Thank you.
All right, thank you.
Thank you.
All right. Court calls the case, West Ridge Mobile Home Park versus William Kopp.
Morning again, Jarrett Levine for the plaintiff.
You say no? Okay. William Kopp, I do not have him. You pay for second hearing or second service. If you raise your right hand to be sworn, proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, go ahead, sir.
Thank you. This is a non-payment of rent case. The plaintiff is requesting a possession judgment entered by default based on the defendant's failure to appear. Rent to retain is $769.42 plus cost of $183 for a total possession judgment of $952.42, which would have to be paid in full by June 9th to retain possession.
All right, judgment to the plaintiff, that's by default for possession. Redemption amount in the amount requested with the writ issue in 10 days.
Thank you.
West Ridge Mobile Home Park versus Jessica Holloway.
Jarrett Levine.
I'm here for Jessica Holloway.
And you are whom?
Billy Hubbard.
Do you reside in the premises?
Yes, sir.
Okay. All right, what's the claim in this case?
Oh, for Jessica Holloway, we're showing rent of $569.35 plus cost of $183, total of $752.35. Presently doing all.
All right, sir, where is Miss Holloway?
She's at home with the children right now. Her phone's off. That's my fiance. We've lived together for the last 15 years at the same address.
Like he's an occupant, but not a
Yeah.
Yeah,
named, not
he's
a
been
named
listed
tenant.
on other cases. That's fine. So how are you intending on getting this paid?
I have the money right now.
Okay.
For this month, my only issue was I wanted to come to the court date because my hot water tank basically started leaking and flooded the back room. So I didn't know I was going to have that expense. So I had to spend this month's rent on that to get my new hot water tank and piping put in. So then now I have next month's rent on me right now, but I can pay that what I owe right now, but I'd still be late about a week and a half to 2 weeks late of next month's rent. So I wanted to make sure that was
Sir,
okay.
how much can you pay right now?
All of it.
All of the $752.32?
Yes, man. Or yes, sir.
All right. So what I'm going to suggest that you do is you get that paid. If you can get it paid before the end of today, then get that paid. This case will be dismissed, and then try to work something out with the landlord as to how you're going to get June paid. Otherwise,
I
what's
can
going to
have
happen
June's
is
rent
June
too.
will be in.
Right.
All right. So I'm going to indicate that you're going to pay that today. I will adjourn it out to June 6, 2025 at 1 p.m. If it doesn't get paid, then you'll need to appear in person on that date.
Okay, June 6th at what time?
1 p.m.
1 p.m. And that's in person?
Yes, sir.
Okay.
All right. Thank you.
Thank you.
Court calls the case of West Ridge Mobile Home Park versus Carmen Terraza and Javier Ruda. Terraza, Ruda, no response. You may proceed, counsel.
Thank you. Based on the defendant's failure to appear, we're requesting a possession judgment for a rent to retain of $496.97 plus cost of $236 for a total redemptive amount of $732.97. Would allow for writ to issue after 10 days unless the defendant pays the total amount.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested with the writ to issue in 10 days. West Ridge Mobile Home Park versus Philip Traver.
I'm here.
Okay. What is plaintiff's claim, counsel?
For Mr. Traver, we're showing rent due, let's see, $896.93 for rent to retain, cost of $183, total redemptive amount of $1,079.93 presently due and on.
All right. And sir, how are you intending on getting that paid?
Well, I've got a pretty big check. I just finished my pay week runs Friday through Thursday. So I just finished a big week and I can get I'm not 100% sure what that's going to come out to be. Obviously, my problem was the week I was going to pay rent, I was pulled from the site that I was working at and missed out on that overtime. But I can have stuff going forward as far as next week. And I mean, I'm trying to do everything that I can, including I used your QR code up there, and I'm talking with places about rental assistance, but I'm a single male. You know, it's not easy for single males to get that. But
Okay, have you contacted anybody regarding any type of assistance?
I just left earlier today the community economic development credit or counselors. They gave me something for Catholic Charities, and then I also, while I was sitting here, because I couldn't find a link to get into this Zoom meeting, so I came right to the court building. So that's where I'm at right now. And while I was sitting here waiting to come in for this, I even sent quick emails to, I guess it's called Hawk, and then another one.
Let me ask you this, sir. How much do you think you can pay prior to next week?
I think doing the quick math with taxes and everything, maybe around 700.
Okay, is that, you think you can pay 700 or thereabouts?
That'll be Thursday.
All right. So I'll put, you're gonna pay 700 by June 5th, 2025. I'll set this hearing for June 6th, 2025 at 1 p.m. That is an in-person hearing. And by June 5th, what's your monthly rent, sir?
I think it's the 580 plus the 480 or the 43 for the water all goes together in this place.
So about 600 there, give or take?
I think it's like 623.
Okay. All right. So we'll see, get the 700 paid and then show up next week and we'll see where we go from here.
All right. Like I said, I'm trying to do everything. I even did your QR code and I was doing that while we were waiting. So I just don't know how do I submit that? I did it on my phone with a app called Zoho.
Actually, if you're at the courthouse, you can fill out that form and you can submit it to the court now if you've applied for assistance.
All right. Thank you.
Oh, thank you. West Ridge Mobile Home Park versus Shaquille Wells.
Oh, Your Honor, the Wells case is dismissed. Okay.
Court will dismiss that case. That's without prejudice on plaintiff's motion.
I'll send in orders.
All right.
Have a nice rest of your day.
Good seeing you, sir.
Good to
Take
see
care.
you.
Peninsula Place versus Abby Cullen.
Good morning, Your Honor. Jillian Engen for plaintiff.
Abby Cullen. There's no response. If you raise your right hand, I'll let you proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $1,550.34. Court costs are $230 for a total of $1,780.38, and that's 80. Your Honor, was there personal service in this matter?
Attached.
Okay, then Your Honor, this is going to be for possession only. Plaintiff requests a writ to issue after 10 days, which I have is after June 9th, 2025.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested with the writ to issue in 10 days. Hold on one moment, counsel.
Thank you.
And why isn't that stamped?
Oh.
Court does, I got another one. Court does call the case of Carly Kenny versus Peninsula Place versus Carla Kenny.
Jillian Engen for plaintiff.
Hello.
Hello.
Carly? Hello.
Yes.
All right. What is plaintiff's claim?
Your Honor, I have a balance including court costs of $2,579.10.
Okay. How are you intending on getting this paid?
I have all of it, Your Honor. I'm able to pay it today. On top of that, I got paid last night, so I can take care of more than half of June's rent on top of that currently.
All right. Okay.
Yep.
You got a plan. So here's what we're going to do. You've got the amount that counsel's indicated, right?
Yes.
Okay. So you say you can pay that today?
Yes.
All right. Pay that balance today. If you get it paid by today, then the case is going to be dismissed.
Okay.
Okay. I will, however, adjourn it over to June 6, 2025 at 1 p.m. But you won't need to appear if you have everything for May paid up.
Cool.
Okay, prior to that date. So,
all right.
Okay.
On top of that, another important bit of information. I looked and the portal for me to pay rent is actually blocked right now. I'm assuming you guys are gonna undo that in the system so I'm able to pay my rent.
Well, it's not my,
or
these different portals work differently. I don't know, Miss.
Yeah.
I'm going to make a note from my client that the portal is blocked. I'm hoping that it can be opened up today. I haven't spoken with him. I don't know how it works.
Okay. So well, let me ask you, does Peninsula Place take payments at the office if it comes down to that?
I was about to say, is there any other form of payment that we can go through with?
I'm sorry. I wish I knew right off the top of my head.
Okay.
Let me give you my email address.
Right.
In the chat, and then why don't you email me and I will, that way I can, I'm just going to put it in the chat. It's going to go to everyone, but.
All right, Carly, if worse comes to worse, if you get that, I'm just going to say this on the record this way, because I think that you're trying to pay it. I don't know this locking in the portal thing, whatever.
Yeah.
If for whatever reason you can't get it paid or counsel can't work it out for you to get paid, then what I want you to do is I want you to get that amount in cash, bring it down to the court and put it in our escrow account. And then you still, if that amount's in my escrow account and I'll give you till Monday, because I'm not going to have you stressed trying to rush today.
Yeah.
Get it down here by Monday. If it comes around to the 6th, I'm going to dismiss this case because you paid or you tried to pay it. Okay.
That's fine with us, Your Honor.
All right. So just see if that can work out. See if you can get it paid to them. If you can't, and then pay it to the court, and then I'll take care of it from there. Okay.
All right. And then just in case I do have to do that again, what was the exact amount for that again?
I have a current balance, $2,579.10.
All right. I was just making sure that
definitely
was correct, because that's you know, it varies from the document that I have right now, but it's fine.
Right, it's gonna vary from the complaint.
Yeah.
And it's also gonna vary because of the court costs included.
Yep, exactly.
All right. Okay. All right.
right.
Take care.
Thank you so
Try to
much.
get that worked out. If you can't, then get it down here on Monday. You have a great weekend.
You too.
All right. Thank you.
Thank you.
Peninsular Place versus, is it Yaya Kissy? Or Sissy?
Jillian Engen for plaintiff.
Hello, good morning. I'm Yai
Good
Fantasy.
morning. Okay. So I got it near right, your name?
Yes, close.
Okay, hey, then I'm having a good day. All
Yeah.
right. All right, what is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $908.18.
All right. You said $8, 08?
908.18. Yes, sir.
All right. And how are you intending on getting that paid?
So after the court was made, I paid 300. I'm planning on paying 200 today, and then within the next 2 weeks, I'm starting my second job Tuesday. So once I get my paychecks for the next 2 weeks, I'll be able to pay the remainder.
All right. So you said you paid 300, right?
That's reflected on the ledger, Your Honor.
Okay, so that's already taken off.
Yes.
Okay.
And then you say you can pay 200 by when?
Today.
Okay, so you're gonna pay 200 today.
Mm-hmm.
All right. And how much is your monthly rent?
$689.
$689?
Mm-hmm.
All right. So and it sounds to me like you've got a plan. It's just not going to occur to get this case dismissed by the end of the month. So get that 200 paid. Okay. And then I'll adjourn this out to June 6, 2025, 1 p.m. And then we'll see if we can work this out. Okay.
Okay.
All right.
Okay. Thank you.
All right. Thank you. You have a great weekend.
You too. And sorry, Your Honor, is this in person?
Yes, it's in person.
Okay. Okay.
I should have said that. Thank you for
No, you're welcome.
reminding me.
All right. Thank you.
All right. You take care. Court does call the case of Peninsular Place versus Amy, is it Diagne?
Jillian Engen for plaintiff.
No response. She is.
Excuse me, Your Honor.
Yes.
Yes, this is Fantasy. She's my roommate. She was having issues with her computer. Can we give her 1 minute to just use my device?
All right.
Okay.
All right, I'll pass that.
Okay.
Thank you for letting me know, young lady.
Okay.
Peninsular Place versus Crystal O'Connor.
Jillian Engen for plaintiff.
I do see. Crystal O'Connor, you'll need to unmute. Oh, there she moved.
Hi, Judge.
How you doing? All right, she's
I'm
here.
good.
All right. All right, what is plaintiff's claim in this case?
I have a balance including court costs of $2,472.88.
All right. And Crystal, how are you intending on getting that paid?
I have DHS. I'm gonna, when I get off of work today, I'm going to go to the office and get a ledger, what they need, and send that in. And then I also have Washington County Community Health trying to help me as well, but my appointment with them is not until June.
Is when?
And not until June.
Okay, what day in June did you say?
The 7th.
The 7th. Okay, so you got community mental health.
And then I also get paid on the 4th, every 2 weeks. So I was going to put my whole check towards whatever was left.
Okay, so let's do this. You're gonna do DHS, and then you got folks at Community Mental Health trying to help you.
Yes.
And then you're gonna get a check on the 4th. How much do you think you can pay on the 4th?
They cut my hours at work, so my check's been 500. I was thinking 400.
Okay, here's what I'll do. I'll put 400. I understand what you're indicating to me, and you'll pay that by June 4th. And then we'll have to figure out something. Do you know how much your monthly rent is?
863. I believe.
863.
Yeah,
Okay,
I
so
believe.
okay, so here's what I'm gonna do. I'm going to first of all adjourn this to June 6, 2025 at 1 p.m. Okay?
You said June the 6th?
Yes, next Friday.
Okay, next Friday. Okay.
Yes, that's
At
at
1
1
p.m.?
that's at 1 p.m.
Okay.
Okay? Here's the other thing I need you to do. Do you know how to use a QR code?
Yes.
Okay. So you can either do that. There's a QR code on your screen. You'll have to swipe across because you're on a phone. Or if you look in the packet that was delivered to you regarding this court case, there's a form called a rental assistance form. You'll need to fill that out and get it down to the court by Wednesday.
Okay, so which, because I got like 3 of them. I got 3 court dates in the mail. I mean, I got
Right.
2 in the mail
But-
and 1 on my door.
Right. Looking, hold on. Just look in any of those packets. There's a form in there called a rental assistance form. You'll just need to fill that out, especially if you applied through DHS. Once they give you what's called a tracking number, you'll need to fill that out and get that to the court by Wednesday.
Okay. Okay.
Okay?
I think I got my tracking number already. 'Cause
Okay.
I put in the SER like a week ago.
Okay. So what you need to do is make sure that everything is filled out on that form and that that tracking number is on that form. Okay?
Okay, I can do that. And you said by Wednesday?
Yes, by Wednesday.
Okay.
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 Okay, then we'll see you next week. Okay?
Okay. See you next week.
All right. You take care.
Is
Bye-bye.
that in person?
Yes, ma'am.
Oh, okay.
Okay? All right.
Okay, that's great.
Take care.
Okay, you too.
Sparrowwood Apartments versus Regina Agnew.
Jillian Engen for plaintiff.
Good morning.
Oh, there she is. Good morning. All right. And how much is plaintiff's claim in this case?
I have a balance including court costs of $884.
All right. And Ms. Agnew, how are you intending on getting that paid?
I'm paying that Monday, but the office will not open. Doesn't open till Tuesday, where the manager is in there. So I'm going to drop it in the Dropbox. I spoke with him yesterday already. So he said, that would be fine, because on the portal, I can't do it because it says error and he don't know
Okay.
as to why.
Got it.
But
So,
I
but you
have the
won't-
funds.
Hang
I
on.
will. Okay.
But you won't have the money until Monday, right?
Right, Monday when I'll do my, it'll be in clearing my account on Monday. So Monday is when
Well,
I'm.
It'll clear it except that you have June rent.
Yes. And I spoke with him about that, and he said the 13th is fine.
I got you. So here's what we'll do. I'm going to indicate you're going to pay the 844. You're going to pay that by June 2nd.
That's 884, correct? Is it?
Yes, ma'am.
Yes,
Okay. Yep.
And then I'm going to adjourn your case out to next Friday, June 6, 2025 at 1 p.m. That's an in-person hearing. And then we'll see what we'll work out for June. Let counsel talk to her client and make sure the 13th is good.
Okay,
We'll move ahead, okay?
Your Honor, So I would have to, when I pay that on Monday, we'll drop it. I would have to appear on Friday. Friday, I had death in my family, so it's a funeral. The funeral is Friday. So
all right. So here's what I'm going to ask you to do.
Okay.
Contact the attorney's office.
Okay.
And see if something can be worked out prior to that time. Okay.
Your Honor,
Okay.
if Ms. Johnson
Yes.
Agnew has a funeral on Friday, I think I think we would be okay to adjourn to the next week.
All right. Very good.
Okay.
All right. So, ma'am, we're instead of the 6th, you need to appear on the 13th.
Okay.
And that time is at 12 noon.
Okay. And now I have a
Okay.
question. So I'm appearing on the 13th, and that's the date that I'm paying the June.
I got
as
you.
well.
I
Okay.
got you. And if you can get that paid before noon, this might all work out where it gets dismissed.
Okay, great. Thank you, Your Honor.
Okay.
And attorney.
Thank you. You have a great weekend, and sorry about your loss.
Yes, thank you. You have a great weekend as well. Bye-bye.
All right. The Haven versus Whitney Albright.
Jillian Engen for plaintiff.
Whitney Albright. Good morning.
Okay, there you are. Oh, good
Hi.
morning. All right. And what is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $2,633.55.
All right. And ma'am, how are you intending on getting that paid?
I get paid on Wednesday and can make that payment. I just had to present my thesis last month for my master's, so unfortunately I had to take off 2 weeks and got a little behind.
Okay. All right.
Yeah, I know.
Yeah, it's okay.
I'm sorry.
So you can pay that by the 4th, you're telling me.
Yes, sir.
All right. So what I'll do is I'll just indicate that balance by the 4th. But then what's going to happen is your June rent's going to click in. So when are you intending on getting that paid?
I'm hoping, I just don't want to commit to it. I'm hoping that I will have that as well on Wednesday. I just don't know the exact amount. I worked a
You
lot
don't
of
know.
overtime.
I gotcha.
Yeah, so I don't
Okay.
want to say yes and then it be a little short, but I definitely, and I'm at work now and I'm working all kinds of overtime to get caught up.
Okay. All right. So get this balance, this 2633.55. Get that paid.
Okay.
Then I'll adjourn this out to the 6th, 2025.
I do
at
have a
1
question.
p.m.
I'm sorry.
Yes, ma'am.
I am scheduled to work on the 6th. I would really hate to give up hours. Is that something that I can get changed to a different date, or is that kind of set?
Well, it's kind of sad.
Okay,
but
that's fine. I mean, that's fine. I just hate giving up time.
okay. Well, do this. If you submit a Zoom form, I'll strongly consider letting you at least appear via Zoom. So
Yeah, I would
miss
very much
time.
appreciate that because yes.
All right.
Thank you.
And then, so get that paid, and then I'll make it June 6th at 1.
Okay.
Okay?
Yeah, absolutely.
All right. What's your master's in?
Mental health nurse practitioner. I just graduated 2 weeks ago.
Well, congratulations on
Yeah,
that.
so this situation sucks, but I'm also so proud of myself. I can't even be that mad.
Sorry, what'd you say?
I said the situation being a little behind on rent really stinks, but I'm so proud of myself. So I can't even be that mad.
And you should be, because
you.
the thing is, this is just, in reality, this is just money, and we'll get that solved.
You're right.
But your education, nobody can take away from you,
I know,
right?
I'm so proud of myself. Thank you.
All right, you should be.
Thank
All
you.
right, congratulations again to you. We'll see you next week.
Thank you. I appreciate it.
All right, take care. The Haven versus John, is it Cristiano? Okay.
Jillian Engen for plaintiff, Your Honor. I have a dismissal for this on my desk, and so I'm
All
going
right.
to be submitting that to the court.
Case is dismissed. That's without prejudice. And then the Haven versus David.
Jillian Engen for plaintiff.
David Green. Do not have him present. I don't think she's been sworn in. Oh, I did swear in. All right, you may proceed.
Thank you, Your Honor. I just want to double check one thing briefly. Unless Your Honor knows if he was personally served. I'm pulling it up
It
right
was
now.
serviced by
Posted.
attachment.
Okay.
Yes.
Your Honor, plaintiff, this is a case for non-payment of rent. Rent to retain possession is $2,250.48. Court costs are $175 for a total of $2,425.48. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested with writ issue in 10 days. Yeah. Recalling Peninsular Place versus Amy Diagne.
Jillian,
she's there.
working in for plaintiff.
Yes, hello.
Hello. Okay, I'll need you to turn on a camera at some point. Oh, she almost did. Okay. All right.
Okay.
There she is. Okay. And what is plaintiff's claim in this case?
I have a balance including court costs of $1,847.54.
All right. Ma'am, how are you intending on getting that paid?
So today I can pay 200 today. And then the rest I can try to pay that on the 10th.
The 10th?
Mhm.
Okay. So we'll see if you can work something out with your landlord. You pay 200 today, and then how much is your monthly rent?
$689.
689. Okay, so that's going to click in. So let me do this. I'll adjourn this out to June 6, 2025 at 1 p.m. Okay, that's an in-person hearing. And so you pay the $200 to him today, and then come down here on the 6th, and we'll see what we can work out. Okay?
Okay.
All right. Thank you.
Thank you. Bye-bye.
And I think that's it for you, Miss Engine, is it not?
I think that's it. Thank you very much, Your Honor.
Okay. Take care.
You too.
James English versus Shanna Snyder.
It says to start your video. There you go.
Hello. Hello. What's your name, sir?
James English.
All right. This is a termination case. And do I have Shanna Snyder present? And I do not have a response. And just checking some things in this case. Is there a lease in this case?
No.
No,
She's not on the lease time.
she's not on the lease.
But the lease is against.
I'm sorry?
She's not on the lease.
Okay, but hang on a second.
There is a lease attached.
Yes, there is. But okay, so you guys are going to have to explain this to me. All right. So, Mr. English, you have the lease?
Yes.
With the landlord? Is that what happened?
And me and my wife are on the lease.
Me and my wife is on the lease.
All right. Hold on. I have somebody that appeared. Galaxy. Ma'am, what is your name? I can't hear you. I still can't hear you. Let me ask you this, ma'am. Are you Miss Snyder? If you are, nod your head. Okay. And so here's my problem. I can't hear you, ma'am. I don't know. Did you sign on with audio? She did. I still can't hear you. All right, ma'am, do me a favor. Let me just, this is my last case in this block, but why don't you, ma'am, Ms. Snyder, if you're understanding me, I need you to sign off and sign back in, and let's see if that will work. Okay? All right. So to the Englishes, I'm going to pass the matter a moment, wait for her to sign back in. Okay? Yeah, it can be.
Let's see if we can get this out. So you're gonna explain this to him, or you're just gonna sit there?
What?
You really didn't understand it. You just nice.
Now, getting no response.
Yeah, she is unmuted.
She's unmuted, but
Oh, figures last case of the day.
yes. Well, now she's just, oh, there she is.
And
Okay,
it's
Miss
Friday.
Snyder. I can't hear. There's
Could she
something
just
wrong with the volume on your device.
could she
Miss
just
Snyder.
come in the house and
Ma'am, please. My courtroom, I'll run it. Miss Snyder? Okay, not if you can hear me. Okay. You're entitled to a 1-week adjournment on this case in any event. So while I'd hear everything, I'm gonna have to set it for a new date.
Excuse me, sir. Could she just come in the house? She's right in my driveway.
Ma'am, I'm gonna end up adjourning it out anyway.
Oh, you are?
Yes. If she
Oh.
asks for it to be adjourned to talk to an attorney or something along those lines, there would not be a judgment issued today. So if you'd
Oh.
let me continue, then I'll
Okay.
do this in the easiest way so
All
that we
right.
can try to get this resolved. Thank you.
I'm very sorry. I just didn't know if you wanted her to be able to say something today. But I'm very sorry.
Miss Snyder. So what I'm going to do is I'm going to adjourn this to June 6th, 2025 at 1 p.m. That's an in-person hearing, so I'll need all of the parties here. Ms. Snyder, if you understand me, nod your head. Okay, so everybody can come down and then we can try to resolve this. This is a termination case where they're seeking to terminate your tenancy. If you want to get an attorney, then you can contact Legal Aid of South Central Michigan, okay? All right, I'm seeing you nodding, so you're understanding everything I'm saying. Okay, so we will see everybody next week, June 6th, 1 p.m. Thank you.
Have a nice weekend.
That's it for that block. Court stands in recess.
Yes, Your Honor. Your Honor, he's currently has a tether on. He has not had any violations. The individuals named in this complaint, not individuals he knows. One was a bouncer, a manager. He's barred from going there, hasn't had any interaction. We're asking this court to amend his bond to have the removal of the tether.
I'll grant the bond request and remove the tether.
Thank you, Your Honor.
The no contact orders will remain in place. You'll go down to Indian County and have that removed, okay? Or you can go to JSG. And then you can bring Stucky up.
Okay.
On the record in the matter of the state of Michigan versus Dennis Cates, 4-0142. Appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people. And good morning, Your Honor. It's the public defender, Aaron Schroeder, on behalf of Mr. Kate, who is approaching and now stands to my right.
Mr. Case was scheduled today for a preliminary examination, uttering and publishing. How are we proceeding?
Thank you, Your Honor. At this time, Mr. Kate is going to be, I understand, waiving his right to the preliminary exam. I believe that the people will be doing the same.
Was there an offer on this?
Yes, Your Honor. The offer on this was the charge of no habituals. The people are also willing to unconditionally waive the preliminary examination.
Mr. Cates, you understand that you have the right to have a preliminary examination in the district court.
Yes.
You understand that you have the right to require the prosecutor to establish that they have sufficient probable cause that the felony was committed and probable cause sufficient to charge you as the person who committed the felony.
Yes.
You wish to unconditionally waive that today?
Yes.
We want the record to get you to waive your exam?
No.
Any promises extended to you to waive your exam?
No.
Your bind over date's gonna be June 11th. That's the date the circuit court gets the file from the district court. You do not have an appearance date on June 11th, okay?
All right.
Your next court date will be a pretrial in the circuit court. You and your attorney will be made aware of that. Do you have any questions at this time?
No, Your Honor.
I have a phone number for you, ending in 9791. That's accurate.
Yes, Your Honor, but it's off right now.
Okay, and your address is still the same on Astor Ave?
No, Your Honor. I'm living in a motel right now. Red Roof Inn.
I'm sorry?
Red Roof Inn, East.
Do you have a room number that goes to that?
134.
Any additional matters for the record?
Nothing on behalf of the people, Your Honor. Nothing on behalf of the defense. Thank you.
Bond will continue, as well as. Oh, there was no GPS, so the bond will continue at this time. You're all set.
Thank you. And let me know what it is. Thank you.
And had sent a copy to Mr. Blanchard as well and to the court.
You can make that, those a reply at 4:39 p.m. You can make the reply on the record. You can make your argument on the record.
Oh, thank you. So, Your Honor, in response to Mr. Blanchard's assertion that MCL 205-28-1F does not apply, that is inaccurate. And the reason that it does apply, and his assertion is that the information is, tax information is already in the possession of the Department of Attorney General, as opposed to being in the possession of a Treasury employee, and that 28-1F would only apply to the disclosure by a Treasury employee. And that's not correct. And the reason that is this is spelled out in my reply, but I'll go through that. You have to start with the Revenue Act, which makes every piece of taxpayer information that's received by Treasury confidential. And 28-1F places exceptions to disclosure of that information. One of those exceptions is pursuant to a court order sought by another governmental agency in adjudication of its matters, criminal matters, other matters. Recognizing there's this exception, Treasury has put in some administrative rules as to the disclosure to get that into those agencies' hands. And that works in the respect of Treasury has a disclosure office, an agency that believes that for some reason it may need taxpayer information from Treasury to handle matters before it would put in a request to that disclosure office, who will send a questionnaire, review that, and determine whether or not it's appropriate or necessary to release taxpayer information to that agency. If they deem that it is, that agency enters into an information sharing agreement with the Department of Treasury, which assures that agency needs to show that it does
To turn over anything that's necessary and appropriate. So I don't see how what they are in possession now would not be considered necessary and appropriate or shouldn't be turned over. Is that, am I understanding your concern?
I'm not sure if I'm being super clear about it. I think the stuff that's in possession of the Attorney General already, that makes perfect sense to turn over. It's the things that Treasury may have withheld in response to the Attorney General's request, and that their disclosure officer may have said is not subject to disclosure under the tax laws. It's that information that I'm not sure how this order seems like it could.
Confidentiality of that. Time we talk.
Present case and preventing public dissemination of PII.
The alley, is that correct?
Correct.
And you don't know. Oh, wow.
I went there to try to senior. And he knew what it was gonna be. The young lady worked very hard to get the paperwork together. This morning, I'm confronted with him giving me a paper saying that he seeks a court-appointed attorney. I have no problem with that. I want to start my weekend early if he wants a new attorney. So I'm not opposed to that, and I'd ask to withdraw.
You're going to jury trial, sir. And this is your attorney.
It's just the fact that I feel that I wasn't represented right.
Nope, stop right there. Let me explain something to you. This is what people don't understand. I don't know why the legal profession is a profession where when you have a client, some of them think it's the attorney's fault that they're in the situation that they're in.
Yes, John.
This is your attorney. And what ends up happening is I require that the state make an offer. The state has made their offer. State, are you going to be changing your offer to Mr. Juan Francisco Ortiz? And if a new attorney were to come in, are you changing your offer to Mr. Juan Francisco Ortiz? No, Judge. That offer is not being changed. Today is your plea deadline date. Yes, if you are not entering into a plea today, then your case is going to trial and it's going to trial quickly.
Yes, sir.
And you're not entitled to a court-appointed attorney.
Okay, Your Honor.
All right, do you understand?
I understand, Your Honor.
And sometimes clients, they don't like the offer that's been tendered to them. Their attorney, your attorney can't force the state to give you what you want. They can't force the state to see the case that they see it or the way that you see it.
Yes, sir.
The state will look at the facts in the case and make what offer they think is a just offer to be made, because their role, according to the law, is to see that justice is done. Do you understand?
I understand, Your Honor.
All right. Now, do you want a jury trial?
Your Honor, I would like to have some legal counsel.
Well, here's your counsel right here. Have a seat. He'll speak to you.
He will.
Thank you.
Thank you, Your Honor.
You're welcome. Bashan, they've rescheduled the Friday night flicks in the park due to rain.
Oh.
So they do it at Woodlawn Park. So
I like that. I like that idea.
They-
I always said I wanted to
go out there and do it, but I haven't made it yet.
Well, I will tell you their upcoming dates, June 13th, A Bug's Life. June 20th, Minions, the latest one. June 27th, Pets. You should take Journey and you should take the pets to see Pets. July 11th is Goofy. And July 25th is Minecraft. Some people said Minecraft was good. I just never really played the game, so I don't know if I should see it or not. Mhm. I think he, okay, thank you. Oh, okay, all right, thank you. All right, and what is the alleged? Ah. Oh, thank you. All right, so I'll set your bond at $10,000. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Brandon Edward Diaz.
All right, so have you used any type of drugs in the past? No marijuana, no alcohol, nothing?
No,
All right, have you ever been diagnosed with any mental health
not
issues?
that I'm aware of. I know that I have anxiety, but never been diagnosed with it.
All right. All right, what I'll do is I'll follow your agreement, set the bond at $10,000. I'll do the referral to Center for Healthcare Services. If you go there and they discover that this is normal anxiety, it's just maybe anxiety about your legal matters, then they may decide something different for you. But just to be on the safe side, I'll do a referral for that.
Okay, thank you so much, Your Honor.
You're welcome. All right, so we can go off the record. So is this going to be a contested?
I need to speak to the prosecutors over in the county court first, Your Honor. I'm just getting discovery on that new case.
Additionally, Your Honor, I guess while we're off the record, today we just asked as part of his bond conditions, the victim that was involved in the original injury to a child charge, that if there was and no conflict order, that still be in place.
Well, let me see.
And actually, that's
Moment, Your Honor.
Sure.
I don't think there's a need for that. He does have regular contact with his children, his child.
Well, what
And
I
there's
can-
not a no contact order as a condition of probation.
All right, well, what I can say is during, and I think I'm very thorough when I'm setting conditions. And if there would have been an issue at the time for him having contact, I would have had it in the conditions of probation. And those conditions are not in his conditions of probation. I'll have probation double check just to be sure though. Bashan, on this case, do you know if he has a no contact order in place with the complainant? I don't think there is, because if I remember this case correctly, the injury wasn't, it was an injury, but it wasn't done intentionally.
Right.
No, Judge, there's not a no contact order in place.
Okay.
And he has completed his parenting class.
Yes, so it was, the injury had to do with
There's a discovery not.
evading. Yeah. I will tell you this, but what I am gonna add to his conditions of bond is I'm adding no driving. Because obviously, and I'm not taking what they're saying is true, but you shouldn't drive.
Yes, sir.
All right. Then, Ms. Ferguson, can you put this for a contested hearing the week of June 23rd? And then counsel, if it turns out it's not contested, that's fine.
Okay.
All right, so it'll be June 24th. And if it's not going to be contested, counsel, if you'll let probation know before that date.
Yes, sir.
All right, Ms. Ferguson, he needs a reset form for June 24th. All right, thank you.
Thank you. Thank you.
As it could have. And so, and I don't know why this happens. You know, when water gets splashed on your windshield, what is your first reaction?
Oh my God.
Yes. Yeah, you close your eyes. And I'm like, open your eyes, Stephanie, before you crash. So, yeah, that was my experience this morning. People just, but I'm glad I didn't wash my car yesterday. Although my mom always says, if you wash your car and it rains the next day, it won't be as dirty as it could have been. So either way, it's good. All right, we're going on the record. The court is calling 2019 CR 8716 State versus Andre Moody. Can I have parties announce?
Opinion for the state of Texas.
Albert Chidas for Mr. Moody.
And are you Andre Moody?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Andre Alonzo Moody who was placed on deferred adjudication in 2019 CR 8716 for the offense of assault, family choking, impeding breath or circulation on June 24th, 2020 for a period of 6 years and extended for 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, we're here this morning on state's motion to supplement pending motion to enter adjudication of guilt and revoke probation.
Oh, I need the supplemental. I don't have it.
I can.
Thank you. All right, Mr. Moody, did you review the state's motion to supplement pending motion to enter adjudication of guilt with your attorney, and did you understand it?
Yes, ma'am.
All right, state, you may proceed.
Yes, Your Honor. Violation condition number 29, on or about the 23rd day of February 2025 in Bear County, Texas. The defendant, Andre Alonzo Moody, did not comply with the rules and regulations of the GPS device 2019 CR 8716 in violation of condition number 29.
How do you plead to that, true or not true?
True.
State, do you waive the other allegation?
There's no other allegation there.
No, there is, because this is a supplemental, so there is an allegation.
Yes, right. We waived the other allegation that was in the original or potential.
Any objection? Oh, no problem. Any objection?
No objection, Judge.
All right, Mr. Moody, did you understand by pleading true to violation of condition number 29, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 29? Court will find violation of condition number 29 true. Is there a proposed agreement?
There's not, Your Honor. I believe we're both hands are open to Your Honor on the appropriate punishment. Given that, just from the state's perspective, we're here on the defendant's third motion to revoke, Your Honor. His first one was filed, looks like it's 3 months after he was initially placed on probation being placed in June 2020. He was first MTR'd in September 2020. And at that time, his conditions were amended to include a TAP evaluation. He was extended for 3 years. Then we come back about a year ago in June 2024 for his second MTR, where the conditions were altered and amended again at that point to add no contact with the victim and partial GPS. Additionally, Your Honor, over his history of his probation, he has had 5 positive tests for marijuana. He has had 2 trips to Bexar County outpatient treatment. At no point had he attempted to even begin his parenting classes in almost 5 years of probation. He has not completed any of his community service hours. He has not paid any of his fines and fees. It appears to the state that he's not interested in completing his probation as required to by Your Honor, and therefore we feel that 3 years prison would be appropriate sentence.
All right, in defense?
Judge, I'd like to call my client as a witness, just.
Sure. Would you raise your right hand?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so that the court reporter can hear.
Yes.
If you just state your name for the record.
Andre Alonzo Moody.
Mr. Moody, you've been on probation for going on how many years?
5.
Okay, and in that time, have you had a place to live?
No. Recently, through that time period, I lost all my family, my mom, my sister, my brother, my dad. And so I haven't had nowhere. I've been struggling. I had to, when my sister passed, my mom took care of the funeral and the cost. But after that, when my mom passed the following year, I had to do it. My brother is in California. He passed in California. My dad was in California. He was in prison in California. So I had to take care of that. So everything that I was kind of like my little stride that I had, my gainings, I lost it. I had to pay for my mom's funeral. Then I had to afterwards pay for my dad's funeral. Then I had to pay for my brother's funeral also. So it kind of took a toll on me financial wise. And for a while I was just depressed. That's what happened with the first violation. When I lost my sister and my mom, I kind of didn't want to be here, like a lot was happening. So
So let me ask you this, so, were you living at Haven for Hope, or were you on the street, or what was your situation?
first temporarily I was with Siobhan Sims, which is mother of my kids, which is the one I have this case with. And
Why were you with her? Didn't he have a no contact order?
no, that was prior to now.
It was after the second MTR.
Okay.
I was with her because we had kids together. My daughter was the main reason. My oldest daughter was the main reason I kind of just wanted to be here. She kind of always wanted to be with me, like do everything. Like my youngest daughter always wanted to go Siobhan, and my oldest daughter always wanted to be with me through them times. She wanted to stay with me.
Okay, so let me ask you, in this time that you've been on probation, have you had any kind of employment?
Off and on, because I was working at Hooters for a while. But again, the consecutive passings of each family member kind of took a toll on me. And I just drifted, mentally I wasn't there for a while. And I started kind of reading the Bible, start putting.
Does anybody have any Kleenex? Do you need that for your ear?
It's.
Oh, okay, yeah, that would be better than
Yes, ma'am.
your finger. All right.
Yeah, so I was.
So you did work, at any point that I know you've been moving around, did you lose your ID or social security card?
Yes, twice, actually. Oh, well, right now I'm on my 11th social security card. And I don't know if anybody knows this, but after you're only supposed to have 10 in a lifetime. Right now I'm on my 11th. I just recently got that back like 3 days before I came to jail. The caseworker at Haven for Hope, she gave me got my birth certificate for me. I haven't had that since I was 17. So I was kind of just getting stuff together because it was when I first got out in October 2nd, it was hard because I didn't have nothing. Like again, I had to get my ID back. I had to get my social. And while it was being my 11th social security card, I can just order it on my social security like I would usually do. And everything is through appointment. So I had to make an appointment to get my ID, but you have to have one to get the other. And that was like hard, And, I finally was able to get the paperwork from the jail, a printout of a photocopy. I don't know what it's called, but I was able to get that. And the ID place took it and gave me my license, which was December like 14th. I went to the appointment and I got my license around January. And then I had to schedule an appointment for Social Security, but they're not taking walk-ins no more. That's an appointment. So I had to wait till February like 18th to go in to get that. And I just received that 3 days before I came to jail. And that was the problem with my employment. I wasn't able to get a job because I was working at a temp agency, which I came to see you in February because it was kind of hard to get myself together because I couldn't get the job. And the only job that I was able to get, GPS didn't want me to do it because it was a temporary job. So I kind of fell off with that, because I was working there. They didn't want me to work over a certain amount of hours. I was trying to get them.
Okay, so let me interrupt you. So you've got your ID, you've got your driver's license, your birth certificate now, right?
Yes, my case manager at Haven has my birth certificate.
Okay,
And they were also willing to help me with an apartment. All I had to do is get a job, a real job, as they call it, not a temp service job, consistently and bring them 4 checks up. They would have paid my first month's rent because it's a program that they have. And, I never got that opportunity because I was arrested as soon as I got all my,
okay. And so in this time that you've been on probation, some 5 years, have you been rearrested?
Yes.
You've been picked up new cases?
I haven't picked up no new cases. I've just been struggling to get on my feet. Every time I start to get like kind of the ball rolling, I always come to jail. And I lose everything again. I don't have nowhere to put it. You know what I mean? I leave it with certain people. It's not there when I come back. I have to consistently start over.
Okay.
And that's where I'm at right now. Right now, I'm at another process of starting over. And again, I finally got everything that I need to be able to work, to go do what I need to do. I'm interested in going to school. Is what I'm trying to go for welding. I was in school going for business management recently, but that was like 2020 after my mom passed. I kind of cut that off too.
Let me ask you, the violation is that you haven't been complying with the regulations, the rules
pertaining to the GPS. Did you visit your kids?
I wasn't able to often, but my daughters, especially my oldest daughter we have like a tight bond. So if I don't go like a long time without seeing her.
Okay, so his question was, were you visiting your children? That's the question.
Yes, ma'am.
Okay, and the kids are in the custody of Siobhan?
Yes, ma'am. Yes,
Okay.
sir.
And you know that after the second MTR, they said no contact with Siobhan Sims.
Yes, sir.
Did you talk to her about visitation?
Yes. She had called me while I was standing there for hope. She called me twice and I didn't answer because of the no contact order. But she texted me and she told me my daughter wanted to speak with me. And I told her to have her call me and they video called me and she was crying. She said she wanted to see me. I haven't seen her in a month. So that's how we set up the arrangement for me to meet with them at the park. And I played with them at the park for about an hour and a half. And I left, and that's how I picked up the violation number 29.
Okay, and do you want to stay on probation?
Yes, I do need the help because I'm struggling by myself. Mr. Boyd, it's hard, and it's been times I don't know where to go. You know, and I do have somebody that's kind of like willing to support me. It's a friend of mine. Possibly girlfriend, just to be honest. And
Well, to be honest, here's the thing. This is what the problem is. He's been on probation for 5 years. He hasn't done anything. The only thing you keep doing is you keep picking up more violations and you haven't learned anything. Now you're saying, I have somebody to support me. That's the problem. You're supposed to be supporting yourself. You're hanging your star to this person to support you. If something were to happen to them, or if they were to break up with you, we'd be right back here on another day with you telling me that you've lost your relatives, which I'm sorry to hear about that, but you were here before saying the same thing. And now you're back again saying the same thing. And now you have somebody else that you're going to be with hanging your star to her. And I think everybody deserves a chance. I know there is love out there in the world, but you got to ask yourself, what is going on in her life that she's decided to hang her star on a person who has no job, who has no home, who has a criminal case pending and is not taking care of his business. So that relationship, I can tell you, that relationship is not going to work out because at some point in time, she's going to get tired of having to lift and carry you on her back. She's going to want you to carry her once in a while, and you can't do it. You can't do it financially because you don't have a job. You can't provide her a home because you don't have one. And as you said it, you're probably going to need another Social Security card because the jail is probably going to lose it. So you haven't done anything. In 5 years, why have you not completed parenting classes in 5 years?
It's $25 a week.
All right. So in 5 years, why have you not had a job? How are you supporting yourself? Were you living off your mom, living off your dad, living off of relatives?
I was working at Hooters prior to my mom. I actually had a savings account and everything.
So why haven't you paid $25 for parenting classes?
That was prior to me even being on probation. My mom passed in 2020. And my sister passed before that. And the funeral, my mom don't even have a headstone for her
No, I understand that.
it costs a lot of money. And I never knew how much it cost. I didn't know, I was just.
But here's the thing, you haven't done anything on probation, nothing. None of the requirements I've set for you, you have done. You have done nothing. Now, with regards to the marijuana, I know you're testing positive for that and you have a prescription. So that's the only thing you've been able to do. You got a prescription for marijuana, but you haven't done parenting classes. You've done nothing. And you haven't done your BIP class. You haven't done anything.
That's $25.
Here's the thing. You're using the fact that you don't have money for anything, not to do anything. And if you were to come into this courtroom and say, Judge, I haven't done the parenting classes or the BIP class because I don't have any money. If that were the allegations in the motion, I would be like, okay. You know what? He hasn't violated his probation at all. He just hasn't been able to do that because of funding. But that's not the case with you. You have done nothing.
Everything that I haven't done is because of funding this board. I don't have.
No,
any-
you violated your probation 3 times. All you had to do was not violate your probation. You haven't done anything. And there's nothing that can be said today that will make me think that you're going to do anything when you're released, because every time you come before me once, another judge, another time, and every time you come before me, it's you have all these plans and you always have somebody. I found somebody who's going to help me out with this now. You're not taking any responsibility for anything. And how old are you?
I'm 32.
You're 32. You're going through life thinking that somebody else is supposed to be responsible for you, and they're not. Everybody gets hit with problems. I know it, funerals are expensive. That's why I decided I wanted to be cremated, and everybody else is saying, I want to be cremated. And you know what they've started doing? Raising the price on cremation. I remember you could get cremated for $2,000. Now it's up to 10. So I understand. Who knows? Maybe I'm just going to die in my house and have somebody let cats come in my house and eat me. I don't know. But what I'm trying to express to you is it is not anybody else's duty to take in an adult male and support them. You're not even supporting your children financially.
Right.
That's another violation of probation. So in the 5 years that you have been on probation, you haven't even supported your children because you don't have a steady job. But here we are, we're going out procreating and we don't have our lives together. I just don't think probation is appropriate for you. And there's nothing else that I can do for you anymore. I tried my best. I told you to pick up the phone, call probation when you need something, come in the court if you need something, and you have done neither. The only thing you've done is violate your probation, and you violated it 3 times, and you've been extended, and extending you doesn't help. You should have been done with this probation, off with this probation, because you've been on this probation for 5 years and have done nothing.
Ms. Ford, can I speak one more time?
Sure.
I just got, like I said, I just got my social security card. I came to you in February.
Here's the thing, when you were placed on probation and you got your first motion to revoke, you had just got your social security card and you're telling me you're getting your life together. And 5 years you do nothing.
And yes, ma'am, and that was my fault because I kind of put, like you said, I kind of depend on other people too much in this, like right now. I depend on a lot of people instead of trying to get things done myself, but I do try to get stuff done, Ms. Boyd. There's been many times that I've been searching for jobs and it just told me no, and I did have an opportunity for a job right before at Denny's. I know it doesn't quite mean anything, but I got my income tax, on my car. I haven't even touched
Here's
it.
the thing, I don't even understand how people are getting an income tax refund and they don't have employment.
I was working last year partially.
All right, and you didn't pay $25 to do parenting. This is what the court is going to do. 29 is true. The court is going to grant the motion, revoke you. Find you guilty, revoke, give you credit for any time served. Does anybody want to speak with regards to time?
Judge, we would just ask for the minimum. All of these have been technical violations. He just can't get his life together. He's not out, holding up a Valero gas station, anything like that. So I think that based on that, the minimum would be appropriate.
And state, what are you requesting?
I'll defer to the court, Your Honor.
All right, the court will sentence you to 3 years in the prison, give you credit for any time served, and the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal, oh, and I'm sorry, there's an affirmative finding of family violence. You have a right to appeal, and that right to appeal is a limited right to appeal. It relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, can I ask one more question?
Sure.
So I do have 390 days or 300 and something days. Is that accounted for as 2-for-1?
Anytime that you, no.
No.
So here's the thing, this is a misunderstanding that people have. The court is not in charge of whether you get 2-for-1 or day for day. That has to do with whatever facility you are at and whether or not they decide to give you credit for that. What I can tell you is I sentence you to 3 years. You will do no more than 3 years. All right, good luck to you.
Thank you.
You're welcome. Did you review the true bill of indictment and each of these cause numbers with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We waived.
State, are you proceeding on the indictments as presented in the cause number ending in 6-8?
Cause number 6-8, Your Honor, we are proceeding on count 1 and waiving count 2.
Any objection?
No objection.
And the cause number ending in 6-7, are you proceeding on the indictment as presented?
Judge, and the cause number ending in 6-7, we are proceeding on count 2 and waiving count 1.
No objection.
And then Judge, just we're waiting the repeater enhancement on it as well.
Thank you. All right, Mr. Ortiz, did you review the documents entitled admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
And the cause number ending in 6-8, the state is proceeding on count 1, which is possession with intent to deliver. Penalty group 1, 4 to 200 grams. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. And the cause ending in 6-7, the state is proceeding on count 2, which is a possession of a controlled substance, penalty group 1B. Uh, 400 grams or more as a first-degree felony. The range of punishment for that offense is anywhere from 10 years to 99 years or life in prison and up to $100,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ortiz, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No contest.
No. Has anyone threatened you or
No.
placed you in fear or coerced you to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page in each of the cause numbers?
Honor.
And the cause number ending in 6-8, the state is proceeding on count 1. And in the cause number ending in 6-7, the state is proceeding on count 2. They're asking that your punishment be assessed at 14 years in the prison. There's a $5,000 fine. There's no applications. The causes will run concurrently, and the state will take in consideration 2025 CR 000621. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Then, and the cause number ending in 6-8 to count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause ending in 6-7 to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
State offers states one out attachments in each cause.
No objection.
Any state you may be excused? I'm sorry, the disclosure.
I have to fill it.
Okay,
out.
thank you. And each cause number, did you review the documents entitled admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes, Your Honor.
And each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are.
That's anything you wish to say on behalf of your client?
We'd ask the court to follow the plea agreement. But Mr. Ortiz has a large family and a loving family. They want him back as soon as possible.
All right. And cause number ending in 6-8. The court will follow your agreement, sentence you to 14 years in the prison, give you credit for any time served. There's a $5,000 fine concurrent with 2025 CR 003667. Taking consideration 2025 CR 000621. And there's to be no residing with minors. And cause number ending in 6-7. As previously stated, the court is finding you guilty. The court is going to sentence you to 14 years in the prison, give you credit for any time served. There's a $5,000 fine. This will run concurrent with 2025 CR 003668. Taking consideration 2025 CR 000621. Did you review the document entitled Trial Court Certification? Also no residing with minors. Did you review the documents entitled Trial Court Certification with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because these are plea bargain agreements, because I followed your plea bargain agreements, because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Let me ask you something. Do you have any children?
I do, Your Honor.
What are their ages?
All of them. One's 26, the other one's 25. I have an 18, a 17, and a 16.
And a 16-year-old. So,
Two grandkids.
and two grandchildren, what are their ages?
One is 5 and the other one's gonna be 2.
Okay. Well, let me ask you something. So these drugs, methamphetamine and heroin, how would you feel if somebody in the chain of selling drugs, hey, I'm just doing this to make some extra money. How would you feel if they ended up with your grandchildren or your children at a party and introduced that drug to them?
I would not feel good at all.
So what you were doing, that could have easily ended up being filtered down to your grandchildren or your children. This whole fast money thing that people are so apt to do, you cannot build your happiness off somebody else's misery. And I guarantee you, if you made any money from this, you probably don't even remember where it went because it wasn't earned correctly. Do you understand?
I understand.
So when you're sitting at the prison, you need to think about your children and your grandchildren and what kind of world you want them to have. And do you want this to be the world? And I read the police report where there are all these drugs in a house and there's a 12-year-old in there. And people saying they love their children. No, you don't. Because if you did, there would not be a 12-year-old when you have all these drugs in the house and they could have easily got into those drugs. And I'm sure those drugs stink to high heaven. You understand?
I understand.
You're going to have to do better. All right, good luck to you. Thank you, Councilman.
Thank you, Your Honor. Everybody changes. I remember the first year you became an attorney. I don't know where I live. I don't know my address, but I remember you the first year you became. But everybody changes. You're one tough person. As you're currently constituted.
No,
No.
still same old nice me.
I'm gonna see what you're gonna be like in 10 years.
In 10 years, you're gonna find me and you're gonna say, Stephanie, how do you have these flies coming out of your arms? You told me you were never going to the Amazon.
Take care of it while you can, Your Honor.
Oh, this is for you and your client.
I recommend Alaska, not on a boat,
Mhm.
but to fly there and rent a car in the summer and time it for the salmon run.
Okay.
I recommend that.
And then I'm gonna end up getting eaten by a polar bear. Okay.
The brown bear, Kelly, the brown bear.
Yeah, the brown bears, because I'm in the middle. Oh, that's right. Alaska, it is the brown bear, not the polar bear. All right, everyone, we're starting up our jury trial at 10:30, so you all need to make things happen over there.